Thank you all for being here tonight to celebrate volume 20 of the UNH Law Review, more specifically, this year's Symposium issue. I know what you're thinking. Nowhere else you'd rather be on a Friday night before Halloween than here with us. Thank you, Paul. Me neither. Seriously, though, it means a lot to myself, my team, the e-board here to have you guys here. So thank you. I need to thank a few people real quick. First and foremost, Dale Kenny. I think she's downstairs getting everything set up right now for after this panel. But she handled all the administrative issues. So we wanted to make tonight an informative event on an important topic, but we also wanted it to serve as a good networking event for our students here. So thank you, Dale. Hopefully she'll maybe watch this after and see that. So I also want to thank AJ Kierstead for listening to all my ridiculous tech-related complaints before this began and helping me set all this up. Hopefully people online can hear, because if not, that would look pretty bad right now. And I want to thank my colleagues on the executive board sitting right here, and I don't know where the rest are. There's a couple around. So for helping me tonight and for listening to me vent about this event for about the last 6 months. So you guys are the best. So we're here tonight to, of course, discuss President Nixon's ever so famous war on drugs as we reach its 50th anniversary. Now, I don't have time to discuss all the negative impacts from the war on drugs and that it's had on the US, but I did want to give one quick example, which I feel is pretty relevant. The Anti-Drug Abuse Act of 1988, our congressional plan to create a drug-free America. One particular provision under that extensive piece of legislation gave landlords, through the discretion of the Department of Housing and Urban Development, or as we refer to as HUD, the ability to evict tenants if guests of their household use drugs, regardless of whether the tenant even knew that the person in the house actually was using those drugs. So for example, to put this into context, a single mother working 3 jobs to provide for her family, who is home 6 hours a day, has a teenage son who smokes some weed with his friends one night when she's not home. The neighbor notifies the landlord of the smoke smell, and now mom may be legally evicted under the act. Again, even if she had no idea that the drug use was actually going on inside her home. As a result, maybe she loses her job. As a result, maybe she can't provide for her children anymore. And as a result, she probably loses her health insurance benefits. She becomes dependent on the state for help. That same state that punished her when things got out of control in the first place. That act that I was just talking about, that passed the Senate by a vote of 87-3 and the House by a vote of 375-30, one of the largest ever. Now, I use this example because it shows some of the negative impacts and this negative light that the war on drugs has had on our nation, and how things have plainly only gotten worse since President Nixon declared it. Drug-related crimes are higher than ever. Opioid overdoses continue to skyrocket. Systematic racism has increased, and political divide about these issues is at an all-time high. This is why we are here today, to have these tough conversations. This is why it is so important that we understand our platform as lawyers or future lawyers. And most importantly, this is why we must hold our political leaders accountable. Our scholars over here and right here at the panel next to me are here to discuss and address these issues head on. I urge you to ask them questions about their work and challenge their viewpoints. However, before we get to them, I'd like to talk to you a little bit about what's happening in our backyard here in New Hampshire. Not COVID, but the opioid crisis, and updates on lawsuits joined by the state of New Hampshire against opioid manufacturers. Our very own Professor Lucy Hodder is here, right next to me, to moderate the panel. For those of you who don't know Professor Hodder, she directs the health law and policy programs for UNH Law, the College of Health and Human Services, and the Institute for Health Policy and Practice. A graduate from Princeton University and Georgetown Law, Professor Hodder has held positions across the board in healthcare law before coming to UNH. She served as assistant AG in the New Hampshire DOJ, a shareholder at Rath, Young and Pignatelli, right here in Concord, here in our backyard, and legal counsel and senior policy advisor to Governor Maggie Hassan. Professor Hodder has extensive accolades in the field of health law and focuses her research on healthcare reform, coverage and payment strategies, Medicaid records privacy, and many others. And we're so happy to have her moderate our panel tonight. Our panelists this evening are attorneys Emily Rice and attorney Jim Boffetti. Attorney Rice currently serves as the city solicitor for Manchester, New Hampshire, where she provides legal counsel and oversees all legal matters involving New Hampshire's largest city. Before serving as Manchester City Solicitor, Attorney Rice served as the first woman appointed by the president to serve as the U.S. Attorney for the District of New Hampshire. Attorney Rice has been extensively involved in New Hampshire civic life, co-chairing the governor's Judicial Selection Commission. She's intensely interested in workforce development and confronting the burdens imposed on the people of New Hampshire by the opioid crisis. Attorney Rice has also served on the faculty here at the law school, where she taught myself and others pretrial advocacy and trial advocacy. Attorney Rice has been recognized by the New Hampshire Bar Association with the Dufresne Award for Outstanding Professionalism, by the New Hampshire Women's Bar Association with the Marilla Rickard Achievement Award, and by the New Hampshire Bar Foundation as an honorary fellow. Finally, we have Attorney Boffetti here. He's Associate AG and Director of the Division of Legal Counsel at the New Hampshire DOJ. He had previously been the Chief of the Consumer Protection and Antitrust Bureau, and before that worked as a homicide and public integrity prosecutor at the AG's office. He also served for 1 year as a Rockingham County attorney, where he worked for 14 years. Attorney Boffetti was the managing attorney for New Hampshire Public Defender, Rockingham County office, where he worked for 14 years. Attorney Boffetti holds law degrees from the University of Maine, a Master of Divinity degree from the University of Notre Dame, and a bachelor's from Stonehill College. He was born and raised in Taunton, Mass, and has lived in New Hampshire for 28 years. Attorney Boffetti has been the lead prosecutor at the DOJ for all its opioid related litigation and national negotiation efforts since 2015. Please welcome me in joining in welcoming our panelists.
Thank you so much, Corey, and thank you to the UNH Law Review. Fantastic to have this presentation, and we're so excited to be here, and to our scholars who are contributing today and are with us. Welcome. We wanted to be sure that we could introduce today's compelling topic with a little bit of an understanding of what we're experiencing now in the aftermath in what is currently the opioid crisis. And in my work at the Institute for Health Policy and Practice, we have been working with the state for the last 4 years, trying to roll out with federal dollars, the state opioid response in the format of the New Hampshire Doorway Program, improving access to treatment, and a number of other things, and been watching on the ground what's been happening with our system of care as we try and grapple with the opioid crisis. And what we're going to talk about, we are going to hear from two of my heroes who are going to talk about their experience on the litigation front, trying to combat a real system, a system that has brought about a result that has impacted our communities in a dramatic and longstanding way. And we as lawyers are going to be listening to this for both the litigation experience, but for how the many different ways what we do brings impact to this problem, and how and where we are today as a result of the last 20 years. Now, I want to say we are in the middle still of the opioid crisis. Overdose deaths from prescription drugs, as we know, quadrupled from 1999 through 2016. And New Hampshire has had one of the highest rates of prescribing per person of opioids during the heyday of the prescribing crisis. Now we are seeing synthetic fentanyl come in as a drug of choice that is causing overdose deaths throughout our communities as well as methamphetamine. And we know from COVID, the rising rates of mental illness and substance use is perpetuating and exposing a system of care that has cracks in it and is impacting our communities in any number of ways. So I'm going to talk a little bit about one is some of the things we have done well. We know that along with mental health and opioid use and substance use in general, go the full degree of population needs that all of us face in community. Housing, access to food, access to resources, access to education, all of the things that one needs are compounded when you're managing the opioid crisis and mental illness in our communities. But let's just think a little bit so we can have a slightly positive perspective before we jump in to the experience of these litigators in the opioid cases. Let's talk a little bit about where we've been. Back in 2013, when we were seeing this crisis coming and we were noting it in the field and the first responders were telling us what was going on in the communities. At that point in time, we didn't have coverage in our health plans for substance use treatment. That didn't come about until 2010 with the ACA, and then that came about with plans that were implemented in 2014. So we didn't even cover services for substance use. We've had to pass laws that protect physicians and protect people from helping people who are in an overdose. We've had to pass laws to protect Narcan, the life-saving drug that you administer to someone in an overdose situation. It wasn't even available except to first responders back in 2013. We have spent so many dollars on treatment and recovery now. We now use harm reduction as our daily mission in the communities that providers serve to try and bring about what is now, we're now able to have needle exchanges. We're now able to administer medically assisted treatment, which is a known treatment for opioid use and addiction. We're able to actually make that available without some really heavy restrictions that existed back in 2013. And the list goes on around harm reductions that we've been able to make available, but were not before. So one of the questions we ask ourselves as we think about the crisis and the policy and the ramifications, it's not just the federal legislation back in the 1980s around criminalizing the use of drugs. It's a whole degree of prohibitions against the acknowledgement of what the health of addiction is and the whole acknowledgement of harm reduction as part of our treatment, education, and recovery motivation. So I'm going to actually ask a series of questions to our amazing panel here to talk about their experience working in this field and taking on the opioid crisis front row. And I want all of you, whether you're online or in person, to please be thinking of questions because we're going to leave a lot of time for questions so that you can ask what is interesting you as well, okay? So the first question I have is for Attorney Boffetti. And tell us a little bit about what was going on in 2017 that caused you to bring your first civil action against Purdue Pharma, which, as I recall, was a request for information at that time. What was going on? Why'd you do it?
Thank you. Thank you for inviting me. I'm happy to be here. I spend a good portion of my life talking about opioids and the opioid crisis. So it was actually 2015 that we issued the first series of administrative subpoenas to opioid manufacturers based on information that there were a rising number of people in this state and around the country that were dying of opioid overdoses. Today, over 100 people in this country will die of opioid overdose. And that happened yesterday and the day before that and the day before that, and going back, many, many years. Thousands and thousands of people are dead in this country because of opioid use disorder overdoses. And most of those people we know now, most of those people started with prescription opioids. They went to a doctor, they got a prescription. They took that prescription exactly as prescribed, and they became addicted. Eventually, many of those people were cut off from their prescriptions, and they moved to street drugs. So heroin, now fentanyl. So we began to have evidence that the opioid manufacturers were responsible for creating a market that said to prescribers and to patients that these opioids were safe, effective, and non-addictive for chronic pain use. That was false, completely, totally false. It was done in a way to create a market, an incredibly effective way of doing it, but they created a market where opioids were the first drug that was used to deal with pain. So if you went to the dentist and you had a tooth extracted, you would come out with a 30-day supply of Percocet. If you went and had a backache or a back injury because you were a laborer, you would get a prescription of OxyContin. And so we began to suspect that this unfair and deceptive marketing, which is illegal, was the cause of this, that they actually were architects of an incredibly sophisticated scheme to convince us that opioids were the answer to chronic pain, and that they were safe and effective and non-addictive, and they weren't. And so we began to ask questions of the drug companies, and we were met, frankly, with fierce resistance and extensive litigation that continues to this day.
Thank you, Jim. And can you tell us, was there a time, when was the first time you got a document from Purdue Pharma in the litigations?
So 2015, we issued the first subpoenas. There was a lot of litigation within the state. It went to the New Hampshire Supreme Court. It went to the First Circuit. Then we filed a lawsuit against Purdue because we felt that they were the most culpable. So my guess is it was probably not until 2018 that we actually began to receive documents. But by then, almost every state in the country and 3,500 political subdivisions, cities, towns, counties, had also filed lawsuits. So there was this growing chorus, and there was this drumbeat of cases that were going on in different places that made them had to start producing documents.
So, Attorney Rice, let me ask you, you are in Manchester. Tell us a little bit about the difference between your position vis-a-vis Attorney Boffetti's and how you have become involved in the opioid litigation, if I might use that general term. And just to remind everybody, Corey did an amazing summary that is attached here because there's so much litigation pending. It will help you navigate the various differences. Emily.
Thank you very much. And thank you, Corey, for inviting us here. And thank you all for coming. I need to give a little disclaimer, which is that my opinions are my own and not those of either my current employer, the City of Manchester, or my former employer, the United States Department of Justice. I became City Solicitor in Manchester in the summer of 2017. Prior to that time, as U.S. Attorney, I had been involved in fairly high-level drug organization prosecutions. But when I came to Manchester, and I'd gotten to know Manchester a little bit over that time with the federal government, I became aware almost immediately that there was litigation against, civil litigation against opioid pharmaceutical companies and distributors. And the way that I became aware of this was that at the very beginning of my employment, my inbox was flooded with law firms reaching out either directly or through marketing companies, asking me whether or not the city would want to get involved in the opioid litigation. And I thought that that was very curious, especially because a few months before I got there, we had actually signed on to be a plaintiff in so-called opioid litigation. And at that time, we were just kind of getting started. So as that decision had already been made when I got there, we signed on with a large law firm. Up until that time, no large law firm had ever been involved in litigation of this type. In other words, many of these law firms were product liability law firms that had lots and lots of experience in a type of complicated litigation called multi-district litigation. And so essentially, these cases began being litigated in the manner that these law firms understood how to litigate. So I'm just going to quickly talk about what happened over the next several years. Bottom line, really nothing. But we filed a lawsuit in Hillsborough County North 4 years ago in September of 2017. Ultimately, that case was removed to the United States District Court for the District of New Hampshire. And then just a couple of months later, in December of 2017, an entity called the Judicial Panel on Multi-District Litigation appointed Judge Polster, who is now on senior status and presides in the Northern District of Ohio, Eastern Division, and who has lots and lots of MDL, multi-district litigation experience, to take over the litigation. Then, as time went on, lots and lots of pleadings filed. One of the several consultants who were hired by the court came up with the idea that there should be something called a negotiation class. I'm sure that many of you are, not to get too technical, familiar with Federal Rule of Civil Procedure 23, which governs class actions in federal courts. It governs things like plaintiff classes and settlement classes, but they came up with this new vehicle. And Manchester was asked whether or not Manchester wanted to participate in this litigation with essentially this gathering or this amalgamation of 2,000 separate actions, and wished to sign on to be in the negotiation class. Well, the very strange feature about the negotiation class is that you have to agree to be in it before you know what the settlement's going to be. So much time was spent talking about, and the reason that this came along was because the judge was very interested in resolving the case and getting the money out into the communities because, as Jim said, people were dying. Well, unfortunately, as time went on, I don't regard this as being unfortunate, but I think the folks involved in litigating were not happy about this. The Sixth Circuit struck down the negotiation class. So then what happened is that ordinary, customary, multi-district litigation settlements were pursued. And at this point in time, we have been asked to sign on to various settlements at the beginning of next year. But up until now, neither the multi-district litigation nor the lawsuit that we filed in the first place has resulted in a dime coming into Manchester. So that is a brief summary. I hope I answered your question.
Well, let's talk about this a little bit. So you have the concept of Attorney Boffetti representing the state of New Hampshire, basically for the purpose of trying to figure out what went wrong and what can be done about it. Same with Attorney Rice for the city of Manchester. Ongoing litigation around it. You have the manufacturers, you have the lawyers litigating. And the question is, what then will happen with these efforts, given what you've proven and what we know? So let's talk a little bit about that. You've talked, we know that there's a bankruptcy judge involved, Judge Robert Drain, in the litigation of the claims against Purdue Pharma and in settling with the Sackler family. And that's been written about quite a bit in terms of what will actually happen as a result of that settlement. And very controversial. New Hampshire has not signed on. Tell us why.
Purdue Pharma, as I said, was probably the most culpable. They're also a privately owned company that was closely held by this family called Sackler, who's made a huge amount of money. The indications are that since 2007, the Sacklers personally withdrew about $12 billion from Purdue for their own personal use. In 2007, that company and officials in that company pled guilty to deceptive marketing of OxyContin, which is pretty much all they make. And so I think the Sacklers sort of saw the writing on the wall and they said, this joyride is coming to an end. We need to take as much money as we can to protect ourselves. And they did that. And then when the lawsuits got to a certain point, the company, the Sacklers, not the Sacklers themselves, but the company filed for bankruptcy protection, and they went to a judge. They actually judge shopped a judge who they knew would be favorable to what they wanted to do. And essentially what they wanted to do was they wanted to get for themselves third-party releases of any civil liability, even though they did not file for bankruptcy protection. So, and that's what they got. They were what's called non-consensual third-party releases. And they went to a judge specifically who was inclined to do that. New Hampshire has stood against that and has said no to the plan. There's a, in bankruptcy, you end up, there's a plan that's put forward, and then there's a vote by all the creditors. So New Hampshire voted no. It didn't make any difference because the plan was confirmed by Judge Drain, and he granted to the Sacklers these third-party releases in exchange for them paying $4.275 billion, which would be used for opioid abatement purposes. Now, you say $4.275 billion sounds like a lot of money, and of course it is, but compare it to $12 billion that they took. And if you look at it in terms of today's money, it's probably more like $20 billion that they were able to put aside. I think there's evidence that came out in bankruptcy case that this 4.275 will be paid over 9 years, and the Sacklers will not touch principal. That tells you how much money that they have. So we've continued to say no. It isn't enough money to pay for the damage that they caused. But the plan was confirmed. It is now under appeal. So a number of states have appealed the confirmation plan. That's going to be going to federal court. I'm assuming the Second Circuit and probably the U.S. Supreme Court by the time this is done. It's a fascinating case to watch. I would encourage you as time goes on to keep an eye on that case, because I think you're going to find it to be something that is really a landmark case in bankruptcy and the abuses of bankruptcy. So even though we voted no, and then the plan is confirmed, if it is ultimately affirmed, then New Hampshire will get money from this estate. But in my opinion, it isn't enough money to pay for the damage that the Sacklers caused.
So let's talk a little bit more about the money, because in a way, money is what the states and Manchester, cities like Manchester, need to support the treatment and various other options that would come with remedying the harm that's been done, if even possible. Will you ever see it? And so first, I'm going to ask in terms of these settlements, a couple questions, because they're really interesting in terms of thinking about the broader wrong and how we remedy wrongs like this in general, how we remedy wrongs when we think government caused it, when we think a private industry caused it, when we, whomever. How do we remedy a wrong like this? And what is the value to a state like New Hampshire? So I'm going to ask Emily first, do you think Manchester, the epicenter in New Hampshire of the opioid crisis, will see resources from this settlement? If not, why not? What do you think is the biggest barrier?
Well, I mean, I think that all of us that have been involved, and I know that, many of you in this room and online, the opioid crisis has touched your lives in some way. And I think that's true of many, many people in Manchester as well. And so Manchester has been very, very energetic and very inventive and very collaborative in coming up with ways to address this crisis, both on individual levels and group levels. So, for example, Manchester was the first city in New Hampshire to stand up a very robust harm reduction plan, which is being implemented now. There are at least 40 organizations, plus various governmental organizations in Manchester who are involved in addressing the opioid crisis and the crisis of substance use disorder in our city. So that's a really good thing, and that gives me a lot of hope. I think that, I personally have gone through an evolution over the last several years. I was listening to the radio yesterday or the day before, and they were interviewing an author named Sam Quinones, who wrote a really amazing book called Dreamland, and now has written a new book. But it was very interesting because he was noting that now across the country, we have a fentanyl crisis, because the drug cartels have moved from plant-based drugs to synthetic drugs. And that made me stop and think, because that happened in New Hampshire 5 or 6 years ago. So fentanyl overdoses overtook heroin overdoses in New Hampshire many, many years ago. So we unfortunately were, at the head of the curve. So now, I really, while I would very, very much like to see the defendants held accountable, I don't think that that's a realistic goal because of the amount of money involved and the amount of people involved. But I do think that at some point, there will be money introduced into New Hampshire and into Manchester. And that's happened to at least a small extent already with the settlement with the McKinsey Consulting Corporation, who, by the way, wasn't sued either by the state or by the city of Manchester. And so there is some money, and Jim can talk a little bit, I think, in a minute about the vehicle that we've created here in New Hampshire for that. But I guess that I'm kind of at the point where every little bit helps. And now, if the money can get here sooner rather than later, I think that would be, a great thing. The city of Manchester, we also instructed our counsel to object to the settlement in bankruptcy court. I have very little faith that that's going to be turned around. And if I were a law student now, I would be looking at some of these creative vehicles like the negotiation class in the district court and the so-called public benefit corporation in the bankruptcy. And I would really be thinking about how these mechanisms are going to be deployed in the future for defendants to avoid responsibility, and also, for example, like the Sacklers, gain the benefit of the bankruptcy system without having to go through the exercise of becoming a debtor in the bankruptcy system. So there are some legal vehicles out there that have developed through this litigation that I think are very, very interesting, but are also susceptible to very, very grave misuse. But I'm hopeful that there will be some money. I don't think it's going to be, a lot of money in comparison to the amount of money that's been spent. But I think it's really, really important that we be forward-looking and that we look at what can happen in our communities. And I have tremendous confidence in the community in Manchester, because they've been doing this work now for, more than a decade. And they have a lot of experience. And I think that they're, to focus on harm reduction and having a, written plan with benchmarks and goals, I think is really, really important. And it's a really great vehicle for people to coalesce around. So if the money should come, I think Manchester has a very good idea about what to do with it and how to be effective.
We're ready. And yes, we want to hear, what is the Public Benefit Corporation? And then how is New Hampshire getting ready for what might come? Because we know implementation and what happens on the ground is sometimes most of the battle.
Yep. So, I think it's possible that over a number of years, 18 years maybe, because some of these settlements have an 18-year payment period. But totally, I think New Hampshire could receive somewhere around $200 million that would come into the state. Here's what we did that was different than tobacco, because this case, from the beginning, I think people felt like we shouldn't make the mistakes we made in tobacco. All of the money that we receive is dedicated to opioid abatement purposes. And that was different than tobacco. This state receives about $40 million every year from the tobacco companies, and not much of that goes into tobacco cessation or public health programs. Some of it does, but not much. So I think there was an intent to say, this has to be different. We have to make sure that the money is used for opioid abatement purposes. And so we passed a law in New Hampshire that says that any settlement money that comes into the state, into any entity, the state or to any political subdivision, would go into an opioid abatement trust fund and would be used for opioid abatement purposes. And we'll see how that plays out over the years. In terms of the Public Benefit Corporation, so that's the other objectionable part from this settlement with Purdue, because the Sacklers wanted out of the opioid business, understandably, and so they came up with this idea that they would turn the company into a public benefit corporation. They would give up ownership, and the company would be run as an opioid company, continuing to make OxyContin, but it would be owned by public entities. So, and every state, every AG would have an ownership stake in the running of an opioid company. I do not think that we should be running an opioid company, especially an opioid company like Purdue that made the exact drug that is significantly responsible for causing this opioid epidemic. But that's what happened. Now that company can only be run for about 3 or 4 years, and they have to sell off the company. But there is this concept of the Sacklers, again, walking away and turning over the company. I think they did it because they wanted somehow to make their name a little bit better than it had become through the course of this litigation. I don't think it's really the way that we ought to be handling these kinds of cases, and I don't think government should be in the business of running companies and an opioid company.
So I'm going to turn to you all to see who has questions, and I'm going to turn to you if there are questions. So please get them ready. In the meantime, while I'm waiting to see some hands go up, I want to ask, Emily, you've mentioned a couple times that there were big law firms involved in these cases. The nature of the beast, large companies, large dollars, big law firms. Can you tell us a little bit about how that's impacted the litigation and your sense of what that means for the future of sort of large torts in this way?
How long do you have?
Yeah.
So, I mean, it's been very interesting. I mean, I spent 20 years of my life in private practice. I enjoyed it. I loved, and I still appreciate my colleagues. But this sort of litigation is very, very big business. And all of us have national counsel. The state does. All of the litigating jurisdictions in New Hampshire that are involved in the MDL, we all have large counsel. And in some ways, we really need that firepower. But the reason that we need it is because of the complications of multi-district litigation. And I would say from my observation, again, it's just my opinion, and I've done some reading about this, that multi-district litigation is very much a closed system. In other words, you can't be an amateur and participate as counsel or indeed as a judicial officer in multi-district litigation because it involves lots and lots of moving parts. And so I think there is some need, for that expertise. But I guess that, again, I would ask the law students in the room and online to think about the ethical implications of that. In other words, if you are in a system where clients have the ability to opt in and opt out of things, how can you go forward and continue to represent both jurisdictions that have opted in and jurisdictions that have opted out? I mean, that's an interesting question to me. I haven't really seen anybody write anything about it. And also I would say that there's a tremendous amount of discussion. And again, I say this kind of, because right now in this litigation, I'm a client representative, right? I don't have an appearance in any of these cases. And I marvel at the amount of discussion and the number of pleadings and the number of orders about how it is that the lawyers are going to get paid. And again, I think it's really important that lawyers be paid for their work, but how much discussion of that should there be prior to the time that any money comes to any of the litigating jurisdictions? And again, the folks that handle multi-district litigation want to continue handling it. And so in some ways, in my view, and this is probably a minority viewpoint, there's a little bit of form over substance. In other words, it's really, really important that you know the system. It's probably not as important as it has been in the course of my career to understand what the needs of your individual clients are. So it's a way of bundling a lot of cases together in order to produce a result. I'm not a student of multi-district litigation. I would assume that because it's still an option and because there's a whole federal system that's created for it, that it has worked reasonably well. But these are just some of the questions that I think about. And again, I have to say, and I'm not being critical of anybody in particular, but here we are more than 4 years in, and the only money that the city of Manchester has received is from a defendant that was not sued, and that was accomplished by the good offices of our Attorney General here. So I guess I'm kind of again, I'm sort of trying to focus on not letting the perfect be the enemy of the good, and trying to get money into New Hampshire and into the city where the people in Manchester know how to use it and know how to deploy it in very efficient and economical and effective ways to accomplish what it is that we're all trying to accomplish, which is to render help and assistance to the people that have been affected by this crisis and their families. And I have to say, while I have the floor for just one more minute, that I think that calling what is being done in the Purdue litigation a public benefit corporation is positively Orwellian. Again, I think that people are going to be scratching their heads about this for many, many years to come. But our objective right now is to get the money here where people know what to do with it to make things better.
Thank you. Corey.
Yeah, we have a quick question, and we'll get to folks here if they have any questions, but I think this one go to Attorney Boffetti. Just really quickly, is the money being spent on litigation as a whole here against these opioid manufacturers, is that litigation expense worth it when that money could be spent on programs simply attempting to help the citizens who are currently suffering right now? If you could just briefly respond to that.
Yeah, so I think an important distinction is that, we've talked about the MDL and Emily has the distinction of being in the MDL with all the other New Hampshire subdivisions. We are not in the MDL. We've never been in the MDL. We're in state court. So we filed our lawsuits here in Concord in Superior Court. We are in state court. We have a trial against J&J scheduled for February 1st. We do have outside counsel, but they are working on a contingency fee basis. So the answer to the question is that except for my time, because I'm the only lawyer at DOJ who's working on this, all of that work has been done by outside counsel. And they have done, in my opinion, extraordinarily good work. And we've litigated this thing extensively because we are preparing for trials. We've done all of the pretrial discovery, and we've done depositions, 50, 60 depositions. We've hired experts. We've litigated all sorts of motions. We're getting ready for a trial to start in February. I agree with Emily that that counsel should be paid for that work, and it was extraordinary. In some cases, extraordinary work. I think a lot of law firms got into it and didn't do much work at all, and are looking for a big payday. And there is going to be a significant transfer of wealth to the private lawyers who did these cases. I'm hoping that there's some sort of a common benefit analysis that is going to be done on this, which is the way it should be. But it does concern me that there is a lot, and I get it. The lawyers we've worked with have worked on this full time. We have like 5 cases going, and so they have been with me every step of the way and helping me to do all that we have to do. And they should get compensated fairly. But the question about how does that actually work at the end of the day, and is that a fair system, is a question that should be addressed. And the conflict, and I agree with Emily entirely, this conflict question with big national counsel that represents a lot of plaintiffs, governmental plaintiffs, and some of them have conflicting views. And yet they seem to be able to stay in all of these cases when they have clients that are adverse in their positions. It's a mystery that this hasn't been dealt with. It's a subject which would make for some great legal research and writing.
It would.
Questions? Yes, and state your name.
My name is Dept. My question is, can you speak to what led you to believe that Purdue is the most culpable?
Sure.
Well, hold on, can you give her the microphone so the people online can hear?
Sure. Can you speak on what led you to believe that Purdue was the most culpable?
Sure. The actual documents, the emails, all of the things that they did to create this market. There have been millions and millions of documents that have been produced in this case. And we've looked at those, the lawyers have looked at those, and there have been depositions, and it's very clear that they were very deliberate in creating a market for opioids that was much broader than what was the usual use of opioids. And opioids were used for end-of-life care, for breakthrough cancer pain, for if you were in a serious accident, and they were short-term drugs, short-term use. They saw an opportunity to create it and put out marketing material that told doctors that these drugs were safe, effective, and non-addictive. And it was it's overwhelming evidence that shows that they were very instrumental in creating this culture of overuse of opioids.
Yes.
My name is Jen. And I was wondering, in terms of national settlement for different class actions, what would be your ideal equitable distribution of that settlement? Would it be based on per capita, like opioid usage, or by population in states?
Okay, well, that's an interesting question. I mean, I can answer it, in terms of the MDL. There was a formula in the negotiation class, which was partially based on something called ARCOS data, a DEA database, partially on population from the 2010 census and a couple of other factors. I think that horse has kind of already left the barn. I think what's happening now is that the percentages for each state are kind of driving the discussion. Jim can tell you a little bit more about the negotiations, but an effort was made by our Attorney General to have taken into account the severe impact of the opioid crisis in New Hampshire, which would not be addressed in the event that it was just a per capita formula. So New Hampshire has negotiated a percentage which is actually above the percentage that New Hampshire would have gotten if it was just based on population. So I'm glad that has happened, because I again, for the reasons I stated earlier, New Hampshire has really been affected disproportionately to its population. It doesn't mean that people in New Hampshire have necessarily suffered differently, but more people in New Hampshire have suffered more than you would find in a per capita calculation. So I'm glad that has happened. I think given the number of dollars involved and the the tremendous moral injury here, I think it's beyond calculation. I don't think it can ever be fully addressed by money.
But I mean, just to give you an idea, in this is how these things happen. You know, it's I was at multiple meetings with AGs all over the country, and they sat down to figure out how they were going to divide up this money. And you know, there's a political process, and there's compromise. And so, as Emily said, we were arguing for some distribution that took into account the intensity of the crisis, and there were these intensity factors that we looked at. In addition to population, you can't ignore population, but you have to also calculate in intensity. So we were partially successful to get it slightly higher, but that's how it happens. You know, you get politicians, and many of these AGs are elected, and they have their own state's interests, and so you get California in the room, and you have New Hampshire in the room, and so you know California is a much bigger get for the companies, and the idea is to get as many states who would sign on to this deal as possible, so that you can strike a deal with the defendants who want global peace.
So let me bring it back to the war on drugs a little bit, because that's our next topic that we're talking about with our learned scholars. And the war on drugs 50 years later, the way we dealt with the war on drugs then was we criminalized it. And in so doing, we criminalized substance use, and we criminalized poverty in many ways. And the impact had an overwhelming impact on our vulnerable populations and even on minority populations. And it created a legacy of stigma. And in fact, criminalization of being vulnerable. And so what have we learned? We now are suing the drug companies. We're going for dollars. We're implementing harm reduction. Have we learned something in the last several decades that actually is causing our response to be different?
Well, I obviously can't speak for what everyone has learned, but I think there's certainly been an evolution of thought and an evolution of action. I think in New Hampshire, everyone knows someone who has suffered from this crisis, and many of us know a lot more than one someone. So it's very personal. I mean, it's right there. You can reach out in one text or one phone call or one meeting. And so I think what we've learned is I think we've learned that substance misuse is a disease like other diseases. It not only affects the individual, but it also affects their family and friends and their community. And so because of the widespread effect, it requires a group, a community, a collaborative response. And so just from my observation in New Hampshire, that is what we have learned. And I think in Manchester, the folks that are involved in harm reduction talk about the importance of helping people walk toward health, and to put in place all of the things that kind of smooth out that walk and take obstacles from that path. So I would say that that's sort of what I've personally learned. But I've also learned that I think people have learned that it's very, very complicated. So, for example, in Manchester, there really are not a lot of misdemeanor drug crimes on the books in New Hampshire. Most drug crimes are now classified as felonies. But we know, even at the misdemeanor level, that unaddressed behavioral health needs and unaddressed substance misuse disorder lead many people to that first criminal conviction. And it may be, it may be a serious misdemeanor. It may not be, but there is not, for example, in Manchester, a drug court for misdemeanor offenders. And the reason for that is because it's not a drug crime. It's some other kind of crime that is the result of, self-medicating a behavioral issue or losing housing or whatever it happens to be. And so now we have to take the next steps. And I think those are all part of our strategy and all part of our understanding now. That is not to say that there aren't drug organizations that need to be assessed and prosecuted. But I think if you're asking what people can do, I think people have learned a lot about what they can do. And I think they've done a lot very, very successfully. And so I think that's the work that really needs to continue.
And, opioids change brain chemistry. I mean, that's the science of it. It changes brain chemistry and it creates a craving for a drug that usually never goes away. And there aren't a lot of effective treatments other than medically assisted treatment, which is providing with things like Suboxone. So I think when people see that and understand that, you have someone that was injured at work, went to their doctor, they took the drugs as prescribed, they became addicted, and now they're on the street because they can't get their drugs anymore, and they get arrested for possession of heroin or fentanyl. And you have to look at it in that lens and understand, and then you have to look at the whole progress of treatment, because relapse is a real thing. It's going to happen over and over again. And so, I started as a public defender in 1993, and it was a very punitive system. I think we have learned a lot. I think the courts, judges understand a lot more about the science of addiction and are willing to look at things differently than they would have 20 years ago.
Corey.
So unfortunately, I feel like we could keep this conversation going a long time, but I'll come over here so I'm actually on camera. But we are out of time with our panelists here. If it's okay with you both, if anyone has questions, I encourage them to send them along to me and I can send them along to Attorney Rice and Attorney Boffetti. Is that fine if you weren't able to get your questions in today? We do have a jam-packed night. So we're going to get started with our scholars who are going to be presenting their articles, which again will be published in our spring edition for the UNH Law Review. So first, Phil Lord will be presenting. Phil Lord, he is an assistant professor at Lakehead University's Boer Alaskan Faculty of Law. He was appointed to this position at age 24, and he remains the youngest professor in Canada. Professor Lord previously served as an instructor at Carleton University Department of Law and was a law clerk at the Federal Court of Canada. Prior to that, he started a few companies, just casually started a few companies, worked in the financial services industry, and practiced civil and commercial litigation in Montreal. Professor Lord graduated from the McGill Faculty of Law with degrees in civil and common law. He subsequently pursued an LLM as a Bombardier Scholar, and he is called to the bar in New York, Massachusetts, and Quebec. Despite all these achievements, Professor Lord has failed at a lot of things. His first 3 grades in law school were B-minuses. And his final law school transcript lists 2 B- and a C, the latter being a particularly unusual grade for a McGill graduate. Although the selection rate seems to hover around 75%, Professor Lord wasn't selected as an editor of the McGill Law Journal. With 4 manuscripts, he spent almost 2 years trying to get his first publication. It would be another year before he published in a law review. Professor Lord now, after publishing several articles, welcomes discussions about his failures, as he thinks law professors too often lack humility. And he actually wrote a law review article on that. We're so happy to have Professor Lord here across the border from Canada to join us tonight and present on his article titled "The Moral Panic in the War on Drugs." Welcome, Professor Lord.
Thank you. The mic's on, right?
Sure.
So hi, good evening. It's good to see you. I'll try to give you an overview of the paper. It's been, I don't know if it's been circulated, has it?
Not full, no.
Well, it's on the internet
That's right.
somewhere. You can Google me. And I spent 2 nights last weekend finishing it up early, so hopefully you'll have a chance to read it. My article essentially applies the concept of moral panic to the war on drugs. So we all kind of intuitively know about moral panic, right? So this kind of idea that people often as groups behave irrationally, they overreact to a threat that they perceive, and oftentimes, right, they'll use the legitimating power of the laws. We'll see especially the criminal law to do that. So the first section of the paper basically describes the war on drugs. I won't go over the facts that we all know about. Just want to emphasize a couple of things that are particularly relevant to my analysis. The first one is the significant public opinion shift that we saw over the past several decades. So when the war on drugs was quote unquote instituted, public opinion was very strongly in support of the criminalization of even very, very nominal amounts of low-level drugs, even though that's no longer the case today. Over 80% of Americans would have supported significant jail sentences for people who had a nominal amount of marijuana. Second thing I want to emphasize is that it was somewhat of an apolitical issue. The war on drugs was conducted by several successive presidential administrations and Congresses, and it was arguably shaped more by Democrats than it was by Republicans. Third thing I want to emphasize is that, of course, it didn't work, right? We all know that whatever the drug-related outcome that we were looking to alleviate was not alleviated, whether that's drug consumption, drug use, drug overdoses, anything. And some of these actually got worse. Significantly, the impact has been very heterogeneous. So the people who were affected the most were people who were historically marginalized, especially African-American men. Second section of the paper looks at this concept of moral panic from a kind of broader theoretical standpoint. So it's been the subject of a lot of analysis in sociological theory. There's basically 7 aspects that we'll identify and use. First one is a concern or anxiety, right? So we get afraid of something and that's why we react. And we try to label that, right, and get rid of it. The second one is hostility. So in reacting, we usually identify a specific group, right, or behavior, but usually that's through criminalizing a certain group. And these people are usually branded as, right, the culprits. They're the people we're going after. And as we'll see, these people are usually people who are marginalized and can't fight for themselves. But you see a kind of line drawing exercise, right? You see a redefinition of the people we don't like, which also helps us redefine who we are, right? Because we're not these people. And we try with that othering exercise, right? It's been labeled in a number of ways in sociological theory. I'll just say it's othering, right? To distance ourselves from that behavior. Third thing is a consensus. So there's a collective aspect to the reaction, and there's also, right, strong public support, at least for the majority, the group that's not being targeted. Fourth is disproportionality, right? We overreact even when it doesn't work, specifically because we're afraid. Fifth is volatility. So unsurprisingly, moral panic will spread relatively quickly, right? Because it's fueled by fear. But interestingly, it also usually subsides relatively quickly. So it lasts for, right? It lasts for a long period of time. Once it starts subsiding, that process is relatively quick. Sixth and seventh thing are essentially the idea that the conduct that we're trying to criminalize is symptomatic. So first, it's a problem, right? It's a big problem in society, or it's portrayed that way. So even though it's not prevalent, right, it's portrayed as being prevalent. More importantly, it's considered to be symptomatic within the group. So the group we're targeting, right, we kind of think that all the people within that group be identified by that conduct. For instance, if we're criminalizing something and saying that what we'll criminalize is we'll see, say, people have different sexual orientations, the assumption is that, right, all people within the group should be targeted. Seventh thing is a moral element in kind of the traditional way we understand it. I emphasize in that, in the second section of the paper, three more things that I think are relevant to my analysis. The first one is the role of the media. So the media has had a very important role in contemporary moral panics and kind of spreading fear and redefining the narrative. Second one is, as I said, that the people who are targeted, and this is not always true in sociological theoretical framework. These people, as we'll see from a number of examples, are usually people who are already marginalized. They're people who can't fight for themselves, and that's one of the reasons why we target them, right? The other might be that they're different, and therefore it's easier to engage in that kind of othering exercise. Third thing I emphasize is that often happens through the criminal law. That's significant because, right, the criminal law might be kind of a natural tool if we're trying to do something big, right? The criminal law has both more systematic enforcement, right? So the state is going to enforce as opposed to people individually choosing to enforce private law tools. And therefore, right, it's arguably both more systematic and fairer in its application, not subject to various constraints. But it also has a denunciatory character to it that is uniquely legitimized in the criminal law. So for instance, in the context of sentencing provisions, we'll often see denunciation as an objective. So in other words, right, when someone has been found to have committed a crime and we want to decide how long we're going to send them away for, we'll consider the fact that what they did is bad. Period, right? That society has to say this is bad. This is not something that we accept, and you're getting punished for that. And that's an objective in itself. And so it's an objective that replaces in a lot of situations more instrumental objectives, right? Like reducing recidivism. And at times may be completely conflicting with them, right? Might increase recidivism to send people to jail for a longer period of time, right? For reasons that we all know about. Severed social relationships, you teach them about lots of things they should know about, right? They start having belonging to certain types of behavior. But we denounce things, and that's valuable in itself, and therefore, right, is legitimized and often considered in the criminal law. The third section applies that framework to the war on drugs. And I draw upon almost equally a speech from Hillary Clinton, which we all know about, where she labels the people, the drug traffickers, super predators, right? That's been in the news for decades. And I justify that choice by saying that moral panics in the war on drugs, right? But moral panics more generally are rhetorical activities. So you have fear, and fear spreads through people, right? Saying things through the media kind of intensifying that. And therefore analyzing the rhetoric, especially the important rhetoric, right? The rhetoric of politicians, which justifies criminalization, that can help us better understand moral panics, not just as an example, right, of what's happening, but as a deep and significant part, because rhetoric is how moral panics spread. So first couple aspects that we see, there's a bunch of quotes from the speech: consensus, fear, and urgency. And you see that in the way Clinton describes, right, the people that they're going after. She says, right, they are people who've lost essentially their souls, right? And she also says that we're trying to protect our kids and that the threats are coming at them from all directions. And you see that sense, right, of first consensus is you've got left-leaning politicians supporting that. Second, fear and urgency, right? She's saying it's a big problem, we got to solve it, right? It's everywhere and we need to do something big and do it now. And then tie that to the work of Professor Desmond Manderson, former distantly related colleague of mine, who's now in Australia, basically who's written the most about this idea of criminalizing drug use and how that relates to moral panic in some way. He's done a lot of work on witchcraft, which was criminalized, right? And also was the subject of very public trials in convicting and punishing, often killing witches at the time. And he says that there's an inherent fear in criminalizing drug use. And that makes sense, right? Because you're really criminalizing harm before it happens. Even if you think that drug use is bad, right? That's kind of the underlying theory, right? Drug use is bad. If we criminalize it, people won't do it because they're afraid to go to jail, right? Unsurprisingly, that's not the case because people who are addicted usually care more about their addiction than being afraid of going to jail. But that's kind of the theory, right? Even if you subscribe to that theory, what you're criminalizing is essentially drug possession. So you're criminalizing drug use before it even happens. And Professor Manderson says that's an intrinsic fear, right? Because we're doing that and we're doing that instead of doing other things like regulating drugs or drug use like we do with, say, alcohol, right? But he says that that can be a fear, not necessarily of drugs themselves, but of drug users, or of the people who are trying to get, say, our kids to use drugs. And he says that in most developed countries, the criminalization of opiates was related to a fear of Chinese immigrants who were poorly integrated. Won't get into that in that much detail, but we'll see there's kind of a parallel with my own argument. Another aspect of moral panics that we see with the war on drugs is disproportionality, of course, because we do something that doesn't work and then we keep doing it again, right? And we do it more. And that's the disproportionality of the reaction that's driven by fear. There's also this idea of othering, and you see that in Clinton's speech in a very salient and interesting way, because both groups that she's referring to are kids, right? So she says, we've got to protect our kids from these, right, bad super predators. They're coming at them from all directions. And the super predators are children. She uses that word, right? Notice the word choice there. And she says, right, they're basically children, but only by virtue of their age. They're people who've lost all their humanity. And therefore, we need to protect our kids from it. So you see this kind of line drawing exercise. You see it with essentially the same population. And that has very deep consequences on how we react. It's true more broadly in the criminal law, right? In the criminal law, we usually label people as criminals, right? We won't say someone who's had significant barriers in life, has a family and lots of things to get back to, and eventually committed a crime. Like we kind of reduce people's identity, at least rhetorically, to the crime, right? The criminal, the person who commits a crime. It's the main thing they do that defines their identity. They're not even a person who committed a crime, they're criminal. And so I argue, kind of drawing on that framework of witches and witchcraft, that that's essentially exorcism, because it's not true, right? We do have things in common with criminals. And in fact, lots of things, right? And there are people, we might have acted in the same way if we were in the same situations. And so that exercise really is about denying that there's that in us, kind of getting the evil either out of ourselves or completely denying it by saying, right, these are the bad people, these are the evil people, and therefore, right, they're the people that we should punish because they're fundamentally different. The last aspect that we see in the war on drugs is marginalizing already marginalized groups. As I said, there's been the most significant impact on African American, mostly men. And they were a population that was already, right, over-criminalized, over-incarcerated with all the consequences that that's had. And I draw a couple parallels, right? Two of the parallels that I have, one of them is to a ban on religious face coverings. I argue that that's also denunciatory, right? So we're trying to say either that the Muslim veil is anathemous to a developed country's culture, or we're trying to say that we're afraid of multiculturalism, and the people who bear the impact of that are usually Muslim women, right? Because Christians don't wear face coverings or don't have to wear face coverings or other religious symbols to practice their religion in the same way as other religions. But you see the impact on a group that's already marginalized of something that's similar to a moral panic, at least is denunciatory in some way. The other example I give is the criminalization of homosexuality. And I quote from the Canadian House of Commons, right, basically our Congress debates, when it was decriminalized, where the legislators were very specific in saying, right, these are bad people who do bad things and they're not, right, they're not engaging in a behavior that we support. In other words, what we're decriminalizing, we never agreed with and still don't agree with. What does that mean, right? It means that essentially the criminalization was denunciatory. Again, right? There's no intrinsic harm to two people, you know, in a bedroom engaging in sodomy. And in fact, eventually there was an exception for when these two people were a man and a woman. But because we criminalize that, even when there's no instrumental goal, right? There is no harm that we're trying to prevent, we see that being denunciatory. And we see again an impact on marginalized groups, namely people of different sexual orientations, right? Who are over-criminalized, and they were people who were already marginalized in the first place. So from the statistical data, there kind of is an indication that, right, the war on drugs disproportionately affected African American, mostly men, as I said. It doesn't mean that they were specifically targeted, right? It might just mean that the people applying the laws were racist and therefore, right, they misapplied the law that was laid down. There's lots of argument suggesting that that's not the case. And the criticism of Clinton recently has essentially been to that effect, right? The criticism isn't that she said super predators, it's that she called African American super predators, which is not accurate, right? But essentially they say that the undertone there is obvious. There's argument to the effect that, right, the fear that she's describing when she says we've got to protect our kids, right, was essentially from African American young men who were fundamentally different. One analogy that I draw, right, that I owe to my research assistant is with the opioid epidemic. And that suggests that there's more, right, intentional line drawing between the races. And we see that from the media coverage of the opioid epidemic, right? You'll recall that media coverage, or the media, is a significant part of moral panics, most contemporary moral panics. And we see a fundamentally different portrayal from studies that analyze very systematically all media portrayal of opioid epidemics, right? We see that African Americans who are, right, who suffer from opioid addiction are usually portrayed as people who engaged in criminalized behavior, whereas white people are usually portrayed as, right, people who are sick, need treatment. And also people who could be, again, just like us, right? So you see, in the same way that I've described earlier, emphasizing shared characteristics as opposed to, right, emphasizing the bad in the person. And that's led to, right, arguably very different public policy responses as well. So that's it. Hopefully made you want to read the paper.
We do have like a couple minutes for questions. Thank you, Professor Lord. No, you're okay. Nicole, want to go ahead?
Do I need the microphone?
So the speakers in this room are very good, I've been reassured, but yeah,
Okay.
maybe.
And
just
feel
in
free
case.
to disagree with me.
Yeah, challenge.
If the bio wasn't an incentive to do that.
So I was just curious because I think when I think of moral panics, like the satanic panic is sort of the one that initially comes to mind. And I was just wondering if you could talk a bit more about how the war on drugs, like what you see as the actual problem versus the imaginary problem that was sort of tackled that makes this a moral panic.
Right. So I'm not sure if there's a population that's being targeted in the way I've described. I'm not sure if there's an actual problem in the sense that you're describing, as opposed to being afraid of, right, an unnamed threat, right? And drugs are often kind of broad enough to cover that, right? And there's other things, right? Might be, sexuality often is portrayed as a threat to our kids. I think it acts often in, it takes the place of broader concerns that we have. And I'm not sure if in the first place there was an actual problem as opposed to kind of an expression of social anxiety about other threats facing our kids, and drugs were something that could easily be targeted and criminalized.
I guess just sort of my thought process is that, crack cocaine was an epidemic similar to the opioid epidemic now. And I agree, that the responses have been vastly different. So I was just wondering if you could kind of address that.
Well, I think at the beginning, there might have been an assumption that that the strategy would work, that right, people would be disincentivized from using drugs. But we've known that that's not the case for a long time. That's true of all drugs, right? The argument about not decriminalizing certain drugs is purely about what I've described as denunciation, right? It's saying it would look bad for us to decriminalize, and therefore, right, we don't want to do that as a society. But we've had that evidence for decades, right? It was clear much earlier that if what you want to do is reduce overdoses, reduce drug consumption even, right? Or at least manage it more appropriately, that decriminalization is the best path.
So in the panel earlier, they talked a lot about how we're starting to implement changes. And I was just wondering, do you think those changes are that we are kind of overcoming this moral panic, or are we just changing the way we view moral panic? And how does that play into some of the changes that we're implementing in the war on drugs?
Right. I mean, there's certainly been positive changes, but there's lots of things that are not socially acceptable, and that we're arguably decades away from having them be socially acceptable, right? Whether that's public injection sites to a greater extent, decriminalizing all drugs. These are all things that probably won't happen in a systematic way that quickly across, right, all developed countries. And so in that sense, yes, it's better, and certainly to stop putting sick people in jail kind of makes sense, right? To treat them instead, also to decriminalize drug possession of most drugs. But again, right, the evidence has shown for a long time that that we should probably decriminalize possession of all drugs, and arguably also regulate trafficking. That's another story. But I think the paper does suggest that that we haven't learned broader things, right? We haven't learned about why we got into that mess in the first place, and how we can make sure that the next thing we're afraid of, we don't overreact to. And certainly, right, it's especially important in the way that it marginalizes already marginalized populations, and with significant consequences, right? The consequences on the African-American population are going to be multi-generational, right? And play on to obviously existing civil rights issues. So I don't think we've learned about these broader issues that much.
Let me give you the mic just in case.
Sure. I'm curious what impact harm reduction has on the redefinition, or as you said, redefining what we means.
What, sorry? I didn't get the last few words.
Sure. So what impact harm reduction has on the redefining of we, as you were saying?
Right. Well, I think the data that I mentioned at the very end suggests that that's not the case for everyone, right? And that we keep over-criminalizing certain groups. And certainly it has first, it kind of redefines our priorities as a society, right? And that's a thing that could have been asked of the panel, whether they think that we've got a problem with how we manage pain, or if we have a problem with the fact that we care that much about pain. And in other words, right, whether doctors should tell people to tolerate pain because that's a lesser evil than the other things we're doing. And in that sense, right, there's kind of a redefinition of our priorities as a society, one that's heterogeneous in the way I've described, doesn't benefit all communities. And it certainly erases some of that identity, right? And that can have beneficial impacts. If you're limiting the ways in which we're fundamentally different from the people we're criminalizing, that can have great positive impacts beyond the criminalization of drugs specifically.
Thank you.
Thank you.
All right, we'll keep it rolling. We'll go to our next presenter, Professor Linninger. Tom Linninger is the Orlando J. and Marion H. Hollis Professor of Law at the University of Oregon School of Law. He formerly served by gubernatorial appointment as the chair of the Oregon Criminal Justice Commission. His scholarship on criminal law and procedure has often been cited by courts throughout the country, including our very own United States Supreme Court. Professor Linninger was very humble in his bio that he sent me, so I did a little more digging. In addition to many avenues of legal scholarship, Professor Linninger's latest work involves advocacy, revisions to ethical and evidentiary codes in order to promote access to justice and ensure fair treatment of indigent parties in court. Professor Linninger has received invitations to present on this subject at conferences, colloquia, and symposiums hosted by, just to name a few, Berkeley, Georgetown, UCLA, Fordham, and Northeastern. Most recently, Professor Linninger received a consumer protection research grant for a project exploring revisions to evidentiary rules which would improve the protection of low-income and minority consumers. Professor Linninger's scholarship has appeared in numerous law review articles, to name a few: Virginia, Michigan, Northwestern, the Duke Law Journal, and the Cornell Law Review, and now, we're proud to say, the University of New Hampshire Law Review. The University of Oregon has given Professor Linninger awards for teaching, scholarship, and service, and interestingly, the graduating class has selected Professor Linninger as commencement marshal in 8 years, the most recent being 2021. Professor Linninger is here with us to discuss his article titled "After the War on Drugs, Challenges Following Decriminalization." Welcome, Professor Linninger.
Mr. Greenleaf had me sweating when he said he dug a little deeper, especially after Professor Lord was disclosing his law school grades. Thinking of bolting for the door. That's not a discussion I'm prepared to have. I admire that you reached that point. That's not a discussion I have. Thank you very much for inviting me, Mr. Greenleaf, and all the editors and staff of the New Hampshire Law Review. I have a lot of respect for your publication. I have huge respect for this school. Not only is this a beautiful setting, but I have some friends on your faculty, and I'll tell a story. Ryan Vaca cut his teeth as a professor at the University of Oregon because I split for sabbatical, and they needed to hire somebody to teach in 2008. And so you can thank me for what I think is one of the best professors in the country, because I wasn't willing to do my job for a year. They brought in Ryan. You're welcome. Another thing that I really admire about your school is that, I'm about to tell you how Oregon, my home state, is a maverick state when it comes to drugs. But every once in a while, we have to copy a model set by another state that's particularly attractive and effective. And I've been talking with Cassie and some others about your Daniel Webster Scholars Program. You may be aware the Oregon State Bar has just pitched to the Oregon Supreme Court that we adopt that on a statewide basis for all 3 of our law schools. And so thank you for innovating that really important program. And honestly, if anybody has ideas about how you might suggest a state emulating you could tweak it a bit, now's the time. I'd be really receptive to those suggestions, because I think really within a matter of months, our state will make a decision about whether and how to adopt our own Daniel Webster Scholars Program. I wish we had such a good namesake as Daniel Webster. Got a real advantage there. So here's what I want to accomplish, and I want to invite your input, questions, as well as other panelists today. We have fantastic speakers on this symposium roster. I'd welcome your thoughts whenever you have a thought or a question. And just raise a hand and I'll be sure to repeat what you say. So jump in. Well, I'm going to tell the story of Oregon's decriminalization and the early results we've seen in the 9 months since our state became the first state in the country to decriminalize possession of so-called hard drugs. And I want to preface this story by being very clear that I'm not taking a position on Oregon's particular formula for decriminalization. I have friends on both sides of this debate. I'm just kind of reporting what we know so far. I also want to be clear that I do not speak on behalf of any entity, including my university or the Oregon Criminal Justice Commission. Everything I say is solely on my own behalf. And finally, I want to say that I really admire the prior speakers, and nothing I say should be construed as contradicting or challenging the prior speaker. Here's the story, and jump in whenever you want. So Oregon has a distinctive political culture. I think New Hampshire shares a bit of this culture. I know how irascible New Hampshire voters are because I went to college in New England and I was one of the least successful canvassers for presidential elections. I was the guy who probably got run off the porch by the, rifle wielding homeowner. You know, a lot of people like me. So I can't say I know much about your political culture. We in Oregon are very libertarian. And while we have some far left constituencies, much like, Boston and, Burlington, we also have some very far right conservative libertarians. And these two sides don't agree on anything except for one thing, which is that they do not want the government to dictate what a citizen must or must not put in that citizen's body. So we have huge fights about vaccines, about not only the COVID vaccine, but vaccines for children. We're one of the least immunized kindergarten populations in the country, last time I checked. Fluoridating water, huge problem in Oregon. And liberals and conservatives agree the government shouldn't be putting any substance in your body without your consent. In the 1990s, Oregon became the first state in the country to decriminalize suicide drugs. So significant is our commitment to individual autonomy. So it comes as no surprise that Oregon's been on the forefront of decriminalization of drugs. We've talked about the war on drugs, which began in 1971 with President Nixon's, famous bellicose analogy. It wasn't 2 years later that Oregon decriminalized possession of marijuana, which means, let's be precise what decriminalization means. It's not legalization. It's basically converting what heretofore was a criminal offense into something akin to a traffic ticket with a small fine. So we did that in 1970. In the following years, I think 2008, Oregon allowed medicinal use of marijuana. In 2014, Oregon was the third state in the country to decriminalize recreational use of marijuana, as well as sale, manufacture, meaning growing marijuana. And so along comes 2020, and there's a group based in New York City, funded by George Soros and some other philanthropists, called the Drug Policy Alliance. And they're very careful about deciding what would be the best arena in which to try and push drug reform. And they selected Oregon. As far as I could tell, it was a very purposeful review of which state would be most receptive for such reforms. It already helped with a campaign in Oregon in 2014. And so Oregon became the theater for the first attempt to, on a statewide basis, decriminalize possession of hard drugs. It passed, and I'll tell the story in more detail in a moment, along with another initiative last fall that allowed the therapeutic use of psilocybin, which is magic mushroom. So let me zero in on the measure that decriminalized hard drugs. First, it may be noteworthy in a state like New Hampshire to know that the campaign for decriminalization of hard drugs in Oregon had 6 million on the proponent side. 5.5 million of that money came from out-of-state donors. 5 million from the New York-based Drug Policy Alliance, and then another 500,000 from Mark Zuckerberg and his wife. He's the founder of Facebook or whatever it is now, Meta. I just, maybe something different next week. By contrast, there was only 137,000 in the opposition coffers, and that came from opponents in Oregon. And so there's a lot of funding nationally for these measures for those groups that want to pursue this, at least in the first round. The campaign themes, I think, have been well developed by Professor Lord. There's a lot of concern about racial disparity, but the number one campaign theme, even in Oregon, a highly libertarian state, you cannot put up a sign that says decriminalize heroin. That's just not going to rally 50% of the vote. But the more palatable explanation of the rationale was something Professor Lord said, and that is that drug addiction, or what we say substance use disorder, is a medical problem. It's a health problem that would be better addressed by a non-criminal solution. So that was the ostensible reason, along with some racial equity issues. So here's what the measure did. It was a 19-page measure proposed as an initiative. And I don't know to what extent you have initiatives in New Hampshire. I'm always amazed by the politics of the state. The fact that you have 435 legislators, it seems like a state that really cares about grassroots democracy. So maybe you have initiatives. We have hundreds in Oregon's history. And basically it presents to Oregon voters, including people who won't even look at the text, a very complicated, multifaceted proposal. And I have some concerns about whether as a general proposition, it's a great way to make any sort of policy, drug policy or otherwise. But here are the different features of our decriminalization measure that passed in November. Number one, simple possession, meaning non-commercial possession of so-called hard drugs, heroin, methamphetamine, LSD, cocaine, eventually fentanyl had to be added. It was omitted from the original version. Up to certain maximum quantities, which were somewhat arbitrarily picked in my view, 40 units of LSD or 2 grams of cocaine or 2 grams of meth or 1 gram of heroin. I'd really be interested to know how they decided where to set the bar. But up to that limit, possession of such drugs in the absence of any commercial activity would be deemed a violation with a $100 fine. Put that in perspective, moving violations in your car typically cost more than $100 in Oregon, which I know from extensive experience. It's just academic research. But then the next tier of possession violations were virtually all misdemeanors under the bill, as long as there wasn't a commercial element. And I think I heard some of the New Hampshire experts say possession is typically a felony in New Hampshire. It's pretty much a misdemeanor in Oregon, absent aggravating circumstances. Then delivery, manufacture, and possession of substantial commercial amounts remain a felony. So in some respects, what Professor Lord described as maybe a good direction in general for drug policy, Oregon is experimenting with. That part, I think, is pretty straightforward. Then the health part had two components. The notion was that we need to steer more people into treatment. So what happens is when you receive this citation, this violation with a $100 fine, you may avoid paying the fine if you'll agree to a health assessment, typically done on the phone, takes about 20 minutes. And in the health assessment, you answer a bunch of questions, and then you get a recommendation from a peer or an expert who will say, you may need to explore drug treatment. If you do that, you don't have to pay the $100 fine. So that was the mechanism in this decriminalization proposal to steer people from the criminal justice system to more of a public health system. And then finally, there was, no worries, that'll happen. That's on a Friday night. Thank you for sticking around on a Friday night. I mean, these are all grumpy people saying, you said you'd come see me Friday at 7:30. What are you doing? She's probably texting back. I'm listening to some weird tall guy tell me about a state I'll never visit. But the final provision I'm summarizing was basically allocating some money for drug treatment. Critics wish that it had been more specific and had a minimum number of beds that would be funded. That's the measure. So what happened? This took effect February 1st. And the data is so preliminary, Corey, this is my way of saying, I'm not going to get you your draft right on November 1st. I'll try and get it really quickly after November 1st. But data is being released right now on what's happening in the first 9 months. Here's what we found out. First of all, police enforcement of drug laws is greatly curtailed. And so what that means practically is that police are neither arresting people for non-commercial drug offenses, meaning possession, nor are police really issuing these citations, which were sort of the way we were going to steer people into the health system. And the explanation for this, it's still pretty speculative. Why aren't officers wanting to intervene in any way? Why won't they even write the tickets that steer people toward treatment? And, Oregon has sort of a recent history of distrusting police. And I think police perhaps are feeling a little more reluctant to interact with citizens with respect to unpopular laws like drug laws. There could be a lot of reasons for it, but the practical reality is there are virtually no tickets being written. And this could improve, but so far it hasn't. The other important detail is the racial disparity attendant to disproportionate arrests of certain marginalized communities goes down if there aren't arrests, right? I mean, so in that respect, you could cite what many people would regard as progress in Oregon. What I'm addressing primarily, because other speakers are focusing on the flaws in the war on drugs, and I'd agree, it failed. There's no doubt about that. I'm focusing in my symposium piece on some of the challenges that remain. Challenge number one, the transition to the public health model has been rocky in the first 9 months. So very few citations are being issued. And then when citations are issued, the vast majority of people with substance use disorder are just disregarding the citation. And it may be because the $100 fine is not something they expected to pay anyway. It may be because our state is not as strict as other states in getting people in trouble for FTA, failure to appear. But by far the most common response to people who receive these tickets is just not to do anything. A few people, in literally the number is 50 or 51 as of October 1st. Out of over 1,000 citations issued, only 51 people have even made the phone call for the health assessment. And then, I don't mean to drill down in too much detail, but some of those calls were not very fruitful. People were just kind of going through the motions. So that part of the new regime isn't working so well. It could be improved. For example, officers might provide more guidance. They might have more interactions, and then the tickets could say more explicitly, here are your next steps, and maybe more people would avail themselves of this opportunity. But remember, the health assessment does not necessarily lead to treatment. The notion of the health assessment was that treatment is most effective when people choose it voluntarily. If you compel people to receive treatment, treatment is less effective. But apparently this is not creating enough of an incentive. Also, we have fewer treatment beds now than we did a year ago, although that could be due to problems related to the pandemic, difficulty of staffing anything, whether it's a restaurant or a treatment center. All right, the second category of enduring challenges, I want to leave time for your questions, is the problems that users continue to experience. Our drug overdoses remain very significant. Hospital visits are actually up compared to the period preceding decriminalization. Fatal overdoses remain a very significant problem. And all the attendant issues experienced by people with substance use disorder You know, the unhoused population is a huge issue on the West Coast, and it could be due to many circumstances. Some would argue it's due in part to the ready availability of drugs. You know, a lot of people are losing their children due to drugs. Now, there are really compelling arguments that proponents of drug decriminalization make in response to those concerns. Overdoses are also high in other jurisdictions that don't decriminalize, right? And a lot of the problems with the unhoused population are due to circumstances other than decriminalization, like the pandemic, like the high cost of housing, right? But further research needs to focus on how people who have substance use disorder have experienced either better or worse circumstances since February 1st. Third challenge is the enforcement of laws other than the drug laws that were decriminalized. So, for example, it's actually quite difficult in this new era to apprehend higher level dealers or manufacturers. And I know that Mike is a former prosecutor and might have some familiarity with one of the ways that officers, you know, it's not surely not the only way, but one of the ways in which officers were able to pursue higher level dealers is to use some leverage on the low level offenders who are caught with simple possession. And that option now is not really available to officers. Now, it doesn't foreclose other means of investigating high level drug traffickers. But some of the early data is suggesting that the decriminalization of simple possession may create some challenges for getting the higher up people in drug organizations. Now, I think a very compelling response would be, we weren't very good at slowing drug trafficking under the old regime, so that really isn't a significant difference. There's also a challenge of prosecuting intoxicated driving, because whereas with alcohol, it's pretty simple, I suppose, certainly compared to other categories of intoxication, to set a maximum blood alcohol level. You just really haven't reached the point of identifying exactly how best to determine somebody who's intoxicated with other drugs. And now in Oregon, one thing that law enforcement is doing is evolving drug recognition experts who will just, you know, describe sort of a gestalt of the encounter, like the appearance of the person and how that person drove, but it's just less precise. Now, there's some really good responses among drug proponents or proponents of decriminalization. They might say alcohol is sort of trading off now with drugs in a jurisdiction like Oregon. Like a lot of people who use marijuana have used less alcohol. And so some people argue that alcohol is more problematic for impairing driving than is in the other sort of drug, or at least marijuana. The final point I wanted to make is that I think it is now necessary to codify in statute certain rules for police misconduct. And it takes a while to lay out this argument, but you may be aware, if you've taken criminal investigation, criminal adjudication, that right now, the Fourth Amendment in many states is really the primary way of sanctioning police misconduct. And so the sanction is evidence is excluded from a criminal prosecution. But when there aren't criminal prosecutions of a certain category of offenses, that disincentive disappears. And states, perhaps citing the fact that the courts are best suited to determine the contours of Fourth Amendment protection, a lot of state legislatures have just left that path to the courts in criminal prosecutions. We have seen in the so-called war on terror, anything that starts with war, probably a bad idea. But we've seen in the so-called war on terror, the shift in law enforcement from prosecuting terrorists to, you know, where prosecutors can supervise investigation of suspected terrorism, not necessarily expecting thereby to get a prosecutable case, but to stop a bombing, but to catch, you know, and nip in the bud a terrorist operation. And when prosecution is not part of the intended plan, there's a lot less concern about protecting people's rights, because frankly, what's the sanction? The sanction is exclusion of evidence. We didn't have a plan to admit evidence. We were trying to stop a terrorist attack. Right? I'll just conclude by saying, if I could advise the state considering whether and how to decriminalize, I'd probably offer 5 suggestions. First of all, I don't think the initiative process is the ideal way to come up with a comprehensive approach to replacing the war on drugs. I think decriminalization is a pretty straightforward idea, but the health part, which really requires, creating this vast infrastructure, it's not well suited for the initiative process. Second, this is huge. The reason why Portugal was successful is that Portugal didn't roll out its infrastructure long after decriminalization. Portugal sort of simultaneously rolled out a new health system at the same time as decriminalization. I think Oregon's biggest shortcoming identified in the recent data is that this 2-stage bifurcated process created a lot of hardship for people in that interregnum period. And so I'd urge that if you're involved in a decriminalization campaign, you really create requirements in whatever law that you're propounding that puts the health infrastructure in place the instant that decriminalization happens. I think otherwise you're not really creating viable alternatives. Another recommendation I would suggest is that there just be data collection that is actually in the statute and a periodic reporting requirement on the success of the statute. I think it's also really important as we consider sort of the national landscape for these measures. I think one thing that Oregon didn't do as well as it could have. Well, I'll tell you what, I'm going to stop with those 3 and see if you all have any suggestions. I think the last 2 I'm going to develop a little better and put them in my article. But those first 3 I feel pretty strongly about. How would you like to proceed here, Mr. Greenleaf?
Take questions however you'd like.
I want to get Mike in the mix, but let me ask you first.
Just
Go ahead.
speak up, Janet. These mics are doing well. So
I'll repeat your comment.
Yeah, I was just wondering, as a trailblazer, if you've seen other states reacting to what sounds like maybe not the statistics that you expected as a result of this.
I haven't heard.
Yeah. Have you seen other states react to the statistics you have about this in a negative or positive way?
So the question was, have I seen other states reacting to the statistics that I just mentioned? Some of them just came out days ago, like the low number of citations. There are a lot of op-eds around the country, like the LA Times editorial board goes, wow, that was a bold choice by Oregon. Let's wait and see before we copy it. I think one interesting response is that a lot of jurisdictions that aren't states, like cities, progressive cities, are interested in experimenting with de facto decriminalization by just declaring, well, they can't change state statutes, but declaring that simple possession won't be enforced in, say, Seattle. And I think that those efforts, perhaps because of the politics that are unique in big cities, people behind those efforts are citing Oregon's decriminalization as a success, because if that's your concern, all the harms that are attended to punishing addicts in the criminal justice system, it was a success. But I think at the state level, there's some trepidation as far as I'm concerned. Did you have a comment, Mike?
Yeah, maybe this will help in your other factors. And it definitely dovetails with what we've written. One of the observations I hope everyone has absorbed over the last 18 months is the remarkable and manifold ways in which people can harm themselves. You mentioned, among other things, that your state is a particularly low vaccination rate. Right. And when I hear that, I think interesting. When we think about decriminalization of certain things that cause harm, I don't think it makes sense to silo our analysis. Oh, so that is to say, we have limited resources. And as filmmakers, we tend to direct the limited resources for areas of moral panic. And one of the questions I think, the contribution that academics can make in this area is to ensure that when they are engaging in analysis, they're properly directing their analysis such that we aren't doubling down on more panic and siloed views of public harm, right? But that we're looking at public harm in a larger context that considers other things that harm us. So for instance, you know, the group of people who are here on the panel, they may say that opioids require enormous outlays of focus and attention, but they won't be able to tell you statistics about deaths due to driving.
Right,
They won't be able to tell you deaths due to heart disease or cancer.
right.
None of them are prepared to focus our attention on those things. Some of them are defending a New Hampshire child abuse and neglect crisis without, you know, being able to tell us about the long-term damage that is attributable to failure to protect children
Right.
broadly from societal harms. And so, I hope as you analyze these questions, you know, you think broadly also yourself about, you know, directing the limited resources of government, which I'm sure you have, in the right way.
No, I'm going to try and restate that so everybody hears it on the broadcast too. But I think Mike's making a really smart point about the overall landscape of sort of a libertarian conception of the proper role of government. And, you know, John Stuart Mill, who's both a libertarian and a utilitarian, said, you know, the government shouldn't really challenge your liberty so long as what you're doing doesn't harm others. Well, I think Mike has correctly identified there are many ways in which my bad choices today are harming others. Like I drove a car a long distance and that's harming others. You know, I'd argue that my choice to eat bad food isn't really harming others, but arguably some of the rationale for criminalizing drugs would apply equally to eating bad food, right? So I think there's a really good academic project that looks at a much wider range of potentially harmful activity by individual citizens and tries to say, you know, where, given our modern sensibilities, should the line be drawn? Did John Stuart Mill find a good partition, or do we need to find a different one? I got 20 pages to work with unless Mr. Greenleaf enlarges it. But no, I think you're, and I bet you'll make some good points about this. It's your turn. But no, thank you for that comment. I appreciate that. Let's see. Have I heard yet from you? Go ahead.
Hi, so you've described Oregon as transitioning the area of drug decriminalization and going from a criminal issue to a public health issue. So I'm curious what sorts of efforts Oregon has made to make like safe usage facilities with this hygienic syringes or medical on-call staff or other sorts of facilities like that, or to combat any kind of contamination in drugs that often leads to these overdoses?
It's a really good point. And so there's a lot of work to be done. It's not expressly addressed in Measure 110, but there are a lot of important health measures. You know, needle exchanges, that's something Portland, Oregon's experimented with. One of the ways that you can prevent addicts from dying when they don't expect to overdose on fentanyl is give them test strips so that people can test the drugs before they ingest them. Wider distribution of those, you know, substances that police or really anybody who's not a first responder can use to revive somebody who has a fentanyl or overdose with another drug. Those are all a really important part of the strategy. And I think maybe just because of the granularity of it, it wasn't addressed in Measure 110, but it's definitely an important part of the strategy.
I'm going to direct we'll get, Paul, I just want to be nice to the Zoom folks as well. John Sheehy, one of our senior editors on the law desk, a good question. I'm interested as well. Under the new regime in Oregon, he asked, what happens to people serving time for drug crimes that have since been decriminalized? And is there any retroactive effects of decriminalization for those already imprisoned?
That's a really good question. And Oregon eventually created a process for vacating marijuana convictions and even expunging marijuana convictions, but it didn't happen right away in 2014. It had to be accomplished through separate follow-up legislation. So I think that's what would have to happen with this measure 110. It is not part of the law yet, but they're already doing several rounds of revision, and I wouldn't be surprised following the example of marijuana legalization. Although I think it's more likely that past convictions would be vacated upon legalization, not upon decriminalization. We didn't see past convictions vacated simply because of decriminalization of marijuana. It followed legalization.
So I guess kind of a follow-up, have you encountered in Oregon resistance or assistance from the federal government on this?
It's a great question. All the questions have been great so far. I'm really glad to interact with this audience. So the federal government has and continues to prohibit even simple possession of marijuana. But what happens is at the national level and then at the district level, there's prosecutorial forbearance or not, I guess, in some jurisdictions. But there are guidelines for what categories of drug offenses will be prosecuted. So there's basically a memo that goes around nationally that says don't prosecute tiny quantities in a state where those quantities are legal. But if they're near a school and if somebody's dealing, or if there's particularly useful role for the feds in sort of pursuing our goal of getting higher level traffickers, let's do it. So in Oregon, since 2014, there have been a lot of pretty brazen activities that would violate federal law, and the federal prosecutors haven't really done anything about it. The closest the federal prosecutors came is at one point, our US attorney, who at that time was a Trump appointee, noticed that Oregon was manufacturing a quantity of marijuana so great that it would exceed enough to get everyone high in Oregon for a prolonged period. And, the US attorney said, this is pretty clearly going out of state. And I think it was a way to make sure, that people knew the feds could still act, although there still weren't that many federal actions. Drug prosecution is really reserved now at the federal level for the highest level offenses.
We got time for one more, Professor Davis.
Thank you for being here. I have one comment and one question. So I think a number of states, including New Hampshire, is struggling right now with staffing for public defender offices and prosecutor offices in the wake of sort of the backlog of cases coming through the pandemic. And I think it's interesting, sort of some of the things that one of the solutions to this that's been brought up is to, focus less on prosecuting simple possession type cases and whether that would have an effect on those offices, which I don't know if you've seen, but I think is interesting. But my question is more about family court. And you touched on it a little bit, but in terms of, is family court become sort of a de facto kind of place to almost punish people who are suffering with substance use disorder?
So I assume everyone heard that question because it was Mike. It's a really good question. I think those specialized courts have been quite useful in our state, family court and drug court, in that there's kind of close supervision and, the probation office tends to get more involved. So what is the effect of Measure 110 on these specialized courts? I worry, but I have not seen data to support this worry, that if there aren't criminal penalties, that maybe someone who wants to get a drug user in trouble would resort now to the child removal system and essentially convert that to a more punitive system. And I'm going to guess you know more about that, about family court than I do, but it doesn't have as many of the same protections as the criminal justice system does. So that could be manifestly unfair. I have not yet seen data about that. I have seen data suggesting, and it's medical studies. It's surprising that non-legal scholars have published a lot in this field, but the link between drugs and child removal proceedings, which may not necessarily mean all those child removal proceedings are justified. And I've got a friend who's suing in federal court the state of Vermont for being too aggressive and trying to remove children from homes where there's some drug use, but not really to the extent that. So I haven't seen enough data on that, but I worry about that. I would say this is one unfortunate aspect of decriminalization. I think drug courts are effective in sort of creating motivation for people. It's not always effective, but it's more of a partnership with the person experiencing substance use disorder. And I do worry that there will just be fewer occasions to interact with, in my experience, would have been, pretty successful teams of judges and probation officers. However, technically, drug courts can still get a person who was arrested for theft who incidentally used drugs. So it's not necessarily the case that we'll lose those drugs. I need to apologize. I have to drive back to Boston now for an early one flight. Thank you very much.
Sure. I want to get you here before you.
Oh, I got a swag bag. All right.
All right, thank you, Professor Lininger. We'll keep rolling. If anyone has to get up in the middle of presentations, feel free. I probably already knew that, but just don't want to make you feel bad. Our next presenter, we're going from Oregon to Tennessee, Warren County, Tennessee specifically. Attorney Bailey Barnes. Bailey Barnes is an associate at Galligan and Newman in McMinnville, Tennessee, where he primarily practices complex civil litigation. Attorney Barnes is also an adjunct professor of civil rights at Tennessee Tech University. While relatively new to the legal profession, Attorney Barnes does not come without distinction. At the University of Tennessee College of Law, Attorney Barnes served as the managing editor for the Tennessee Law Review and the articles editor for the Tennessee Journal of Law and Policy. Attorney Barnes received Cali Awards in legal history, conflicts of law, legal process, wills and trusts, wrongful conviction seminar, and federal courts. On top of all that, he graduated second in his class. Attorney Barnes has published works in the Encyclopedia of American Civil Rights and Liberties, the Tennessee Bar Journal, the Dartmouth Law Journal, and has upcoming publications in many others, including our very own. We are delighted to have Attorney Barnes here with us tonight, all the way from the volunteer state of Tennessee. He's here to present The Perfect Storm: Substance Abuse, Mental Illness, and Criminal Justice in Rural America. Please join me in welcoming Attorney Barnes.
Good evening. Like you just said, it's not been long at all, really, since I was in your shoes exactly, being a member of the Law Review. And I can tell you that, recognizing it's a Friday night, that there's probably some compulsory element to being here, that I will follow the advice that I'll follow the advice of an old colonel. And he told me that when public speaking, you are to be bold, be brief, and be gone. So I'll do my very best to do that. Numerous scholars have written on the war on drugs, multiple elements of it. Prior to going to law school, I actually went to history grad school, and they have written numerous books, probably used a lot of ink, talking about the war on drugs and the objective intentions of the war on drugs, which are to eliminate illicit drug use, to stop drug dealing, and then the more subjective intent, which was amongst some policymakers, to find a way to, going back as early as not in this formal war on drugs, some scholars see it as a longer war on drugs. It goes back to right after the Civil War and Reconstruction, and a way to oppress recently freed enslaved people. And then moving forward into the current war on drugs that we're here to talk about, that's 50 years old, talking about still ways to control minority populations, which was the subjective intent of some policymakers. Scholars have written pretty significantly on those issues. What has not been written about is the effect of the war on drugs on rural communities. And so I wanted to talk about that. I come from a rural community. I come from McMinnville, Tennessee. It's a population of 40,000 in the entire county. It's a pretty small town. So I'm used to this and I see this on a daily basis in my profession where I'm at. So to ground this discussion, I want to focus on Warren County, Tennessee, and I want to focus a little more broadly also on Appalachia just a little bit. In Warren County, Tennessee, we're dealing with a population that has a higher rate of poverty than the United States generally, lower per capita income, less secondary and post-secondary education levels. And according to the Appalachian Regional Commission, Appalachia as an entity entirely experiences or self-reports having higher rates of days that they feel mentally unhealthy than the United States as a total. And there's also higher rates of depression in Appalachia. Warren County specifically is noted as an at-risk county, which means it's in the bottom 25% of all counties in the United States on 4 economic factors, which primarily deal with poverty rate, per capita income. Education levels are also taken into consideration. Given those statistics, it's important to note that because we're having higher rates of mental illness, that there's also a connection between mental illness and substance abuse. We've heard about and we know about, but there is a scientific link between mental illness and substance abuse. So what have we basically done through the war on drugs? We've said that people living with mental illness who turn to self-medicating through illicit drugs, which the war on drugs has deemed illicit, are going to be jailed for basically having their mental illness. And the problem in counties like Warren County and Appalachia is there's not enough resources to deal with these issues when people start joining the carceral system, getting brought into the carceral system because of their mental illness. About 4 years ago, before a new administration came in Warren County, both in sheriff's office and in the county executive's office, the jail had about 100 more people in it in the beds it was rated for. People were sleeping on the floors. They would drag beds around with them. I went and toured just to see how bad it was. And they were dragging their beds around the floor, trying to find a better spot that they could lay down because they had all been so over incarcerated that they could not actually find a bed to sleep in. And the recidivism rate at that time was about 92%. Of that, about 90 to 95% of those were drug-related crimes. We're not talking about violent felonies. These are drug-related crimes that are causing an overcrowding at the jail. Once you get to the jail, and this is still the scene today, there are no mental health resources at all. There is no psychiatrist. There is no psychologist. Just last week, Warren County hired its first counselor to go into the jail. This is not a psychologist or psychiatrist. It's someone with a master's in social work who comes in and serves as a counselor to talk to inmates. But if you need some sort of serious mental health treatment, the only option is to go to a state facility in Chattanooga, which is about an hour and a half away, or to be furloughed so that the county doesn't have to pay for it. Because if you go to one of these treatment facilities, the county is stuck with the bill. The county's already cash strapped as it is. Once you're in the system, as I say, the recidivism rate was 92% just 4 years ago. There's a generational effect to that. As more and more parents go to jail and never get out of it, children are left without parents, which harms their educational attainment and stability overall, which can lead to that child then later on going to jail and finding itself in the carceral system. Fortunately, I'm not just here to throw stones at what's happening in Warren County. Those are my people. But there are some solutions. I talked to the county executive about this article before I started it. And I asked him, I said, what could you get? What resources could you have that would help you with the war on drugs? Besides just decriminalization, it is that there is no transitional housing right now in Warren County. And that's true for many counties in rural America. Warren County is actually, when you look at it in Tennessee, it's actually a hub for multiple counties around it. It's better off than quite a few that are directly surrounded or than 2 or 3 counties over. There is no transitional housing. There is not the first inpatient rehab facility. You have to basically beg. I talked to the public defender Friday, the elected public defender, and he told me he basically has to beg every rehab facility to take any of his patients. Because there's just none in Warren County, so you have to get transportation, and then you have to furlough them sometimes. It's a massive undertaking. And there is no social worker that comes and helps at the jail to say, all right, you got to get a job, you got to do these things to help you move on. There's no support for that. There's no support for that on the county commission, because for many of these people on the county commission, they're farmers, and they're people who are not willing to spend the money on people they see as being deviant. And that's what the county executive pointed out to me most. He said, my primary problem is that the people have a stigma here. And it probably goes back to the lack of education. We're at lower levels of secondary and post-secondary education. When they see somebody who's struggling with mental illness, the only option available to them is to pick up the phone and call 911 and have a police officer show up. Once that starts, the system starts at that point of putting the person in jail, and they're going to stay there. And with a district attorney general who is unwilling to recognize that there's a link between mental illness and substance abuse, the only option is going to be jail. There's no rehab facility. There's no transitional housing to send them to. This is not to say that rural issues are worse than urban ones. The war on drugs has failed urban, rural, east, west, north, south. It's failed entirely. But rural issues are a little bit different in that stigma is worse. There is a lack of mental health access. There's a lack of access to providers. And then even if the providers were there, there's a lack of transportation. When you're rural in Warren County and many areas in Appalachia, there is no public transportation system. There's no way to get to a mental health provider, even if there is one. And then once there are no other alternatives to incarceration, because there's no option for anybody who sees somebody struggling with mental illness who's on substances besides just putting them in jail. So what are some solutions to those issues? One, we need to have transitional housing. If we're not going to decriminalize, we've got to find a way to keep people out of jail. Overcrowding jails, it costs $60 a day to keep somebody in the Warren County jail for the taxpayers. It'd be a lot better to put that money in transitional housing. Funding an in-house rehabilitation center, which is what the county executive is hoping to do and pleading with the governor right now to fund. You have to beg and scrap. The only reason they have a counselor is because of a grant that they had to beg for a for-profit entity. And we need social workers who can help connect people from the jail to a job, to understanding how to get your license back, to understanding how, if you want to go get education, how you can do that. Presently, those solutions are just not being realized. So in sum, trying to keep it brief here, the war on drugs has failed entirely, as we've all heard, but it's also impacting rural communities in a way that I don't think is truly understood or intended. It's causing generational effects, and it's leading to people being criminalized for having mental illnesses because there's nowhere else for them to turn except for sending them judges. With that, I'm happy to take your questions.
I'm from Olive Branch, Mississippi, which is about 5 minutes from Memphis, Tennessee. So it's nice to hear a Southern accent. My question is, I have a family member with mental illness. I'm also from the South. So I understand completely the lack of resources. I'm wondering, through my personal experience, I found that there was a delay in mental health treatment. What I mean by that is, unless the person themselves was willing to be voluntarily committed, they then had to be involuntarily committed, which meant that the police would have to actively see that person harming another or themselves in order for them to get involuntarily committed into a psychiatric facility. What are your thoughts on this delay in treatment? And do you see that that also contributes to this pipeline to jail in a sense?
Absolutely. And that actually came up with my discussion with the elected public defender last week. For far too many of these people, they're refusing to go to psychiatric facilities or rehab facilities, probably because they don't want to admit they have a problem, or they don't see themselves as having a problem. Legitimately, they don't see themselves as having a problem. What he gets most often, is he tells me, is that he has people call family members of his clients, and they'll say, well, why can't you make them go to rehab and you not get a conservatorship over them? And he says, the statute doesn't allow me to do that. But he was telling me the only option really is to get conservatorships over these people and then have them involuntarily admitted. Well, of course, the conservatorship process is not particularly easy as well. You've got to get a doctor to certify that the person needs to be under a conservatorship in Tennessee. And getting the person to go to the doctor to get seen about that is a whole other issue. So it absolutely is causing having a delay. And once that delay happens, the next option is getting incarcerated, and you're not going to get the mental health treatment there. And you're not going to get it when you leave.
Right.
Go ahead. No, Professor Davis, go ahead.
It's interesting. I think a lot of the things you were talking about in Tennessee are similar to some of the things happening even in New Hampshire, especially in the western and the northern part of the state, and more so prior to the opiate epidemic. Sort of what the opiate epidemic brought in New Hampshire was a lot of harm and death, but what it also brought was a lot of awareness and resources and commitment. And so I'm wondering whether Tennessee is a place that has been affected by opiates substantially, and if it has, what's the response been? Because it's my experience that typically, opiate epidemic has affected every single community. And so when it starts to affect rich people, it starts to affect white people, lots of people start paying attention and money starts coming. And that's what happened in New Hampshire, it seems, especially. And so if that did not happen in Tennessee, sort of, what do you think was the cause of that?
Yeah, Tennessee was hit extremely hard with the opioid epidemic. And you're exactly right. I think there was a quote from the governor in the State of the State address 2 years ago, in which he wanted to make it clear that the opioid epidemic was a health issue, not a criminal issue. While also he passed a truth in sentencing bill this past session of his own choosing that added mandatory minimums to other types of drugs. So it probably plays into Tennessee's lack of education somewhat. But that's exactly what we're seeing in Tennessee as well. There was an opioid task force that started to see how we could handle these issues, treating them as community health problems rather than criminal problems. And then meanwhile, creating more mandatory minimums for other types of drugs.
Hi, do you see potential for funding coming out of the recent proposals from Congress? For instance, the infrastructure and other social spending bills that could help, the problems you're identifying?
From what I talked to the county executive, and I'm not sure what's all in the bills, but from talking to the county executive, what he was telling me was what they're primarily hoping for was money to build a criminal justice center where they could house some social workers potentially. But he did not know if they would have the funding for the social workers or any type of mental health providers in the criminal justice center. But he did think there would be money to build the facilities that would house them. And that's what he was hoping. But I'm not sure the specific proposals to know. And I think the bill's been cut up and moved around enough that it's difficult to know.
Hi, I'm not sure if you'll have an answer, but I hope you will. without addressing the social determinants of health that are clear indicators of success after incarceration, how do you think that we're going to meaningfully address the carceral system, the recidivism rates in general? It seems that Tennessee is hesitant, and as are a lot of states and communities around the country, hesitant to invest in addressing the issues that really can improve the outcome in terms of drug use.
Yeah, Tennessee is a big believer in the DARE program. So you get talked to by a police officer for 30 minutes for 5 weeks or 6 weeks, and that's supposed to cure all. It doesn't, but they think it does. We need to have legitimate attempts at the young level that when we're seeing high school or even middle school students start to use what we would deem illicit drugs right now, that we talk to them about it in a way that doesn't make them feel like a criminal and talk to them like they're a criminal. Because more than likely, at least in my community, that person who's using those drugs at 15, 16, however young, their parents or someone related to them right up one level is using illicit drugs. And so if we talk to them about it in a way that doesn't make them feel like a criminal, that's a good start. Second, whenever the phone gets picked up to call the police for somebody who's living with a mental illness who happens to also probably be on a substance, we should try and have a crisis prevention team. And Warren County has tried this, but they've used police officers as the crisis prevention team. Unfortunately, when police officers show up, problems typically escalate. Maybe having social workers who go with the police and take the lead, I think would be a good move forward to say, let's address what we're looking at here rather than let's put you in jail and see if we can't let the substance get out of you, and then we'll figure it out down the road whenever we're ignoring that there are no resources down the road. I think getting more towards the front end, and then for those people who are currently in the system, the way to reduce recidivism is supervision, transitional housing. We do have a fantastic drug recovery court in Warren County that has a 35% recidivism rate. About right now, Warren County is seeing about 65%, so it's 30% lower. But you have to have a job and you have to have a home to go to. When you don't have any transitional housing, you just wiped out a significant percentage of people who are no longer eligible for that program. So having some sort of transitional housing, I really think would be a key way to helping lower the recidivism rate.
But without that sort of investment, is there any way that we can meaningfully address the issue? Or are we just stuck until we come around to the idea that there's more than just incarceration?
I mean, without providing funding, I guess, is that what your question is? Basically, if we're not going to put forth the monetary assets to deal with it.
Exactly.
Right. I guess it starts with education and ending the stigma around mental illness and substance abuse and seeing those as a health issue rather than a criminal issue. You can do that with existing resources more than likely if you start young and do something better than DARE. So maybe we can, I think that's one way that you can do it within the existing framework and funding that we currently have.
Yeah, so to the funding issue, to what extent do you think selective non-enforcement could just save money, right? Because they have prosecutorial discretion. They can decide or be told that they just want to prosecute a certain type of offender, and then that money arguably could be redirected to other things, right? Or I might be completely wrong because I know nothing about the criminal law.
I think prosecutorial discretion would be extremely helpful. I've personally sat and argued with elevated voices with the current district attorney in Warren County about how what she says is, well, if somebody's on meth, my only option is to put them in jail. My answer was, your other option is just to not prosecute. She doesn't see it that way. And the issue is, in Tennessee, it's a very deep red state that believes in tough on crime. And if she tries to make any meaningful move away from prosecuting drug crimes with the stigma that surrounds those and the lack of education, she's not going to get reelected. Having a little political courage would be helpful. But yes, I do think that prosecutorial discretion would help alleviate the problem without changing the funding mechanism and would actually save the state money overall.
And did any of that change with COVID, with the backlog, or do they just get people to plead guilty instead?
I'm sorry, I can't hear myself.
Did any of that change with? Yeah. There. Did any of that change with COVID and the backlog, or do they just get people to plead guilty instead?
Well, with COVID, what happened in Warren County was the sheriff told his deputies not to go and serve warrants for nonviolent criminals, which lowered the jail population by almost half. And they still not started serving those warrants at this point, and that's working. And I guess that's more of the sheriff using his discretion, which is keeping the backlog, but the warrants are sitting there. And he actually is getting he has a primary opponent who just announced whose primary claim in the primary will be, there's a backlog of arrest warrants and I'm going to tell the deputies to go out and get them.
One more question for you. So the Community Mental Health Care Act under JFK deinstitutionalized a lot of mental health facilities and wanted to put a more emphasis on community care for those individuals. We saw a lot of increase in homelessness or unhoused people as a result. I'm curious, as you're saying here, there's a lack of resources in the rural communities. How can you deinstitutionalize something that never existed? So did your community at all feel anything, impact of this at all? Or do you see an increase in unhoused individuals as a result of the lack of resources? Or does your community feel that at all if there were never any resources to begin with?
I think because there have never been any resources, the unhoused population typically goes to Nashville where there are plenty of shelters. And there's literally one shelter that has 6 beds in it in Warren County. That's not to say that we don't have unhoused people. We do, but what typically happens is they'll only stay on the street for a very few amount of days before somebody will call the police and have them arrested for whatever. And the police are more than happy to oblige to find some reason to arrest. Sadly.
Anyone else? We have time for maybe one more? Yeah. I
can yell, it's fine. I got it. I'm wondering, in sort of the link that you have here, substance use, mental illness, and criminal justice, what sort of you're addressing as mental illness. So is it, mental, diagnosed DSM diagnoses, or is it cognitive, developmental disabilities as well? Because I think, sometimes those things get mixed together. Those groups of people get mixed together, and they have definitely different needs in terms of treatment. And it sounds like there's not a lot option anyways, but, and I think it combines with, I don't know your perspective on this, but sort of environmental factors in terms of especially, especially with kids and how sort of environmental factors, things like lead can affect, kids in their communities and then sort of, create this pathway, towards criminal use and criminal conduct and substance abuse. But I guess more specifically, I'm asking about your article. Is it about mental illness or both?
It's more about both because I do think it's a broader issue. For instance, I know of quite a few people in Warren County who use meth to treat undiagnosed ADHD, and that it's extremely prevalent. And so I think it's a much broader thing than just diagnosed mental illness. And so I'm addressing it as the broader issue because I see clients who have that exact problem, which is I think I have ADHD and I think meth to treat it.
All right. Go on. All right. We're almost there, guys. You're doing good. I appreciate you sticking with me on a Friday night. Last but certainly not least, we're going to welcome 2 of our very own to talk a little bit about marijuana. We have Cassie Moran She is a third-year law student at UNH Franklin Pierce School of Law here. She is a Daniel Webster Scholar and a managing editor of the UNH Law Review. Cassie has served as a teaching assistant in legal writing and pretrial advocacy. Michael Lewis, who co-authored the article that they will be discussing tonight, is a shareholder at Rath, Young and Pignatelli here right around the corner in Concord. And he also serves as an adjunct professor at the law school and at Vermont Law School, where he teaches sales and commercial law. At Rath, Professor Lewis has served as lead counsel in matters before the nation's federal trial and appellate courts and before its highest state trial and appellate courts. Professor Lewis's writing has been published widely in popular press and legal publications, including several publishings in our very own UNH Law Review. Before joining Rath, Professor Lewis served as assistant AG at the New Hampshire DOJ. For his work at the AG's office, Professor Lewis received the Robert E. Kirby Award from the New Hampshire Bar Foundation in 2012, recognizing excellent advocacy, civility, courtesy, and perspective as a practicing attorney under the age of 35. Professor Lewis has also served as an associate at Arnold & Porter, an international law firm in Washington, D.C., and he clerked for the Honorable Judge Barbaduro right around the corner here at the Federal District Court of New Hampshire. We are happy to have Professor Lewis and Cassie here to discuss their article titled, "Is There a Rational Basis for New Hampshire's War on Marijuana Anymore?" Join me in welcoming them.
So I'm going to go quickly, and I really want to facilitate a discussion on this issue afterwards because it is so prevalent and it raises many constitutional issues that could affect many of our laws. So we really used our study of the war on marijuana to think about the war from a standpoint of rationality and reflect on how this application really informs our understanding of rational basis review. And ultimately, our main conclusion is that the New Hampshire war on marijuana is irrational, especially for a state that consistently advocates for its live free or die ideals. The live free or die state is the only state in New England that is yet to make significant progress on marijuana legalization, and the only other state where marijuana is not legal in the region is Rhode Island, and legalization is coming in a matter of days at this point, whereas in New Hampshire, it's very far off. So generally, this war has focused on claims regarding public safety and health, but we argue this end does not stand the context of the laws themselves. When we look at other things New Hampshire allows, both substances and activities, they really do not stand the test of rational scrutiny. So I'm just going to briefly discuss the current marijuana regime in New Hampshire, and then I'm going to talk about rationality, why it's important, and what should inform our understanding of rationality when looking at marijuana. So it's important to understand New Hampshire has not always been strict on drugs and marijuana. It was one of the last states to pass comprehensive drug laws in the 1960s. It is one of 3 states that has not adopted the Uniform Controlled Substances Act. And it was actually the first state legislature in 2004 to vote to legalize marijuana. So the fact that it is so strict compared to its neighboring states is an anomaly. The first major step to liberalize New Hampshire's marijuana laws came in 2013 when the state legalized marijuana for medical use. And interestingly, even so, it is the strictest in the region for who qualifies and how the dispensaries must operate. Then in 2017, the state decriminalized up to 3/4 of an ounce of marijuana. So it's a $100 fine, which is similar to a traffic ticket. However, if you possess more, it is still a misdemeanor or a felony, and it's still in some quantities punishable by up to 20 years in prison or a $300,000 fine. So these laws really aren't working. Even though it is decriminalized, 43% of all drug arrests in the state are still for marijuana. And the state is expending vast resources on enforcing these laws, even though there's thousands of case backlog in the Superior Court and it's years delayed. And this is especially concerning because these laws are still applied in a very discriminatory manner. People of color are 4 times more likely to be arrested for marijuana possession even though it is decriminalized. So in the context of these laws, we have to understand what rationality is before we can understand whether or not these laws are in fact rational. Rationality is based on the rational basis review standard, which is highly deferential to the legislature. So it's thought to be democratic, so we don't allow the unelected judges to overturn and make policies. And generally, a law is upheld as long as it has a legitimate government interest and the law is rationally related to that interest. However, this is often applied in a very cold, impartial, and irrational manner. One case that really stands out is Buck v. Bell, which was a case from the 1920s that allowed for forced sterilization under the reasoning because the legislature passed it, they had an interest in doing so, and their interest was related. So it is very cold and impartial. It doesn't consider the context of the human realities, and it doesn't consider how these laws actually operate. There is another version of rational basis review called rational basis with a bite. And in some cases, it is used to look at sort of laws that affect people more directly. For example, in Massachusetts versus Department of Health and Human Services, which is a case involving the Defense of Marriage Act, Judge Boudin of the First Circuit applied this stricter version of rational basis review because it was necessary, because it affected people and it had a more human element. However, this stricter version and less deferential standard has not been applied to marijuana. There was a 2015 case in the Eastern District of California challenging the federal classification of marijuana. However, despite the effect it had on the defendants and despite the testimony from medical experts, the court ultimately concluded that the marijuana scheduling was rational. And we ultimately argue that that is not correct, that we need to look at the human experience involved in the enforcement of these laws, and we need to look at the policy in the context of the broader state sort of context. So before I specifically apply this to New Hampshire's law, it's important to sort of go through what else New Hampshire allows that implicates these same policies of health and safety. New Hampshire allows alcohol and they sell it at state-run stores. They allow tobacco and caffeine, each of which has caused more overdoses than marijuana or more addictive than marijuana and have more long-term health effects than marijuana. In 2020, the New Hampshire Supreme Court legalized drug use for sincere religious practices in the case State v. Mack, despite the fact that these drugs do still cause these health concerns that the state reportedly cares about. New Hampshire allows burgers and unhealthy food, despite the fact that the leading causes of death in the United States are cancer, heart disease, and obesity, and those all contribute to widespread suffering and death. And also New Hampshire allows a lot of dangerous activity that other states do not. It is the only state in the country that does not require seatbelts, which save thousands of lives annually. And car accidents are a leading cause of death for people in their 20s and 30s. New Hampshire is one of 3 states that has no law requiring helmets on motorcycles, despite the fact that they save thousands of lives annually. And New Hampshire has very permissive fireworks laws, despite the fact that fireworks cause tens of thousands of accidents every year. So this really just highlights how inconsistent New Hampshire is at these purported policy justifications. If they truly cared about public health and safety, why criminalize marijuana or why punish marijuana use while they allow these other more dangerous activities? And in some cases, like alcohol, actively support it in their own sales. Also, it's important to consider, when considering the rationality, these laws, frankly, do not have public support. Marijuana is actually more popular than Governor Sununu. And a May 2021 survey of New Hampshire voters found that 75% of voters supported legalizing marijuana, while only 68% approved of Governor Sununu's job. And many people in New Hampshire do smoke marijuana more than any other state where it is not legal for recreational use, except for Rhode Island, which again is just days away from legalizing the drug. So with all that context, I guess I want to know what everyone else thinks, if we should sustain these laws as constitutional or whether they should fail rational basis review.
I have a two-part question, which plays into each other, I promise. The first one is, where do you stand on the decriminalization of illicit drugs? And if that is less than ideal in your mind, what do you make of the idea that marijuana is this gateway drug? And how does that play into your argument that it couldn't survive rational basis review if it led to more use of hard drugs, so to speak?
So I think marijuana is unique because it doesn't necessarily have the same health effects as harder drugs such as heroin or cocaine. We haven't really looked into that. So I think I would need, at least personally, need to do more research into the effects and how it relates to those public health and safety goals. But as for the sort of gateway drug argument, I think there's an equal argument that either tobacco or alcohol are gateway drugs, and we allow and encourage the sale of those. So I don't think that would support a ban on marijuana.
Cassie, I have a quick question. Have you guys been tracking, you and Professor Lewis, have you been tracking I believe I saw an article on it last week, that New Hampshire just failed again to try and pass marijuana legalization. That was real recently. I don't even know if you've gotten the chance to update that or look at it in context, but was it close? Do you know if it was compared to others? Just real quickly, I just thought that was interesting.
It was not close. It died in committee. It has, so there's been a bill to either legalize marijuana or to study the legalization of marijuana every year since 2010. And it has gone as far as like getting enough votes to pass in one house, either the House or the Senate, but this time it died in committee. So it wasn't as close as we've been.
One of the things I think is important to discuss here is, and it's in response to your question about quote harder drugs, it's prefaced by the question I asked the professor, which is, and it's related to Professor Lord's presentation. When you're bringing the force of the state to bear for policy reasons, it's important to ensure that it has an effect that's positive, that's rational and justifiable. And it has been the case, and you've been taught this in constitutional law, that there's a view that the legislative branch, the administrative apparatus in this country is entitled to some great level of deference. And I think that it's important to reflect on whether that's justified given the damage some of these policies have done to our country. And it's also important to reflect on the branch of government that most of you will spend a great deal of time in, the judicial branch, and the great potential capacity of the judicial branch to facilitate a real focused, rational discussion about the effects of policy on people. And Buck v. Bell is a very important counterbalance, because Buck v. Bell is cited by Judge Boudin as the sort of the root of the branch of rational basis review inside challenges to DOMA, which was a federal regulation restricting the recognition of marriage only to heterosexuals. And Judge Boudin is a super thoughtful man. I mean, very brilliant jurist. I think very purposely picked Buck v. Bell as just sort of as the root of the most deferential form of rational basis review because of the cruelty of that decision. I mean, the decision is a case where Oliver Wendell Holmes, who is embedded in all of your minds, whether you know it or not, as a principal mover of your education and the jurisprudence that you're taught here as American law students, was about as cruel as a judge could be with regard to a woman with mental illness in determining whether she should be sterilized or not under a policy that was eugenics policy in the mid-Atlantic in the early 20th century. That's horrifying, horrifying. But that is the genealogy of rational basis review. So, when you're taught rational basis review by Professor Gravy, for instance, you're taught about it in the context of a desire to defer to the New Deal and to progressive economic legislation. But its genealogy has also a darker side to it. And it's a side that encourages judges to look the other way and not to permit challenges to cruelty that we see day in and day out in American courts. And that's a huge loss, I think, systemically. The question you ask about harder drugs is an interesting question that can't just be tossed aside. I mean, given what New Hampshire appears de facto not to care about, as Professor Davis alludes to, there's a real question about New Hampshire's commitment to public safety around even the enforcement of things as potentially dangerous as heroin, fentanyl, and opioids. We don't fund our systems of public safety and prosecution. We don't fund public defenders services. We don't fund our courts. We have huge backlogs. So any hue and cry about caring deeply about the damage that these substances do to people, in a system that really asks questions about rationality, would have to face up to the realities of our commitments to people in this way. And I think that's one of the, what we're hoping to do is contribute to discussion at that level in this paper. Fair? Fair, Cassie?
Yeah.
Okay. Anyway, yeah. Nicole.
Hi, Neil.
Yeah.
So I'm just wondering, into your research, what is your sense of, being that New Hampshire is the live free or die state, why is there so much resistance to the legalization of marijuana that it can't even make it past the state?
At least from my research, and I don't know if Mike agrees with me, it's very political, it seems. Even the most recent decision last week, it was very partisan in the way it went down. And our current governor has said he refuses to sort of even entertain the idea of legalizing marijuana. So I think that's definitely part of it. But I think a lot of it also is just a very reactionary sort of, I guess, mentality. So even if we do have this live free or die culture, there's also this sort of underside of it that, unlike our neighbors, tends to be reactionary.
So you mentioned the political issue, and one thing that's not political is money. So how much, has your research shown how much money New Hampshire is potentially losing by not legalizing marijuana and not being able to tax it?
Yes, so in 2018, the state had a commission to study the legalization. And ultimately, it was between $13 and $50 million would be the extra revenue that would come in from legalizing, taxing, regulating marijuana. Which is a lot, and it could solve a lot of, I guess we sort of, at one point, we're going to look into what could that solve? Like what problems could New Hampshire solve with $50 million? But we ended up not going down that route. But there would obviously be a lot of sort of things that New Hampshire could address were they to take that sort of policy decision.
Yeah, I'm just curious as to how that was calculated, because one of the things we saw in Canada when they legalized it, I was alive when that happened, and one of the things I thought was going to happen was they would not eradicate the underground market because they were selling it for more, and I was completely wrong. People are willing to pay more for government sanctioned weed. So is that included in the calculation in any way, or are they assuming they'll tax all sales?
So the study did it based off of other states that had legalized it, but I don't know to what degree it considered that. Because I know, for example, in California, the underground market is very successful because of all of the regulations. It is still cheaper on the black market, so people are sort of going through that way to get their weed.
That's true. It's interesting. There's a Wild West aspect to what California is going through, and even with that observation, I still think that there's a rationality problem. That is to say, even if there was that risk, there's still a rationality problem, because every problem that you could identify as being a problem with underground trade in marijuana, you could also identify in other areas that we permit in New Hampshire that are more dangerous and have for a long time. So anyway, I mean, yes.
I just think, do you think New Hampshire would have had the same path as the opioid crisis never happened? Because I think sometimes you're going to look at it as a gateway, or you're going to look at it as sort of a state suffering under the crisis of a very real, sort of dangerous, drug. The marijuana sort of lumped in there and has a good resistance.
Marijuana has always been improperly lumped in with other harder drugs. I have no doubt that that politicians fail to distinguish opioids, fentanyl, and marijuana in terms of the threats, and that is a product of fear about political ramifications and unwillingness to do, the right thing. I think by the people of New Hampshire who suffer as a result of these policies. I mean, I guess the hope is really in this room and in succeeding generations. That is to say, if you ask the question, in my mind, what the problem is, I suggest someday when it's safe again to go and look at the New Hampshire legislature and study why it looks and is comprised the way it is. It's a volunteer, essentially volunteer position, and that results in people being elected to positions who have time to do policy on a volunteer basis, which means that those of you who will go out into the world with immense student loans and a need to take on jobs that will pay them off are unlikely to defer your student loans to run for the legislature and participate in that way, and that will go on for the next 15 to 20 years at least. And so we'll have a lagging indicator, lagging response problem, I think. But I mean, one of the things that Professor Linenger said, which I thought was really fascinating, was, and this is, I wish he was here because I would say this, he was critical of the amount of money that poured in out of state in Oregon to criticize their approach. But if you view in context the amount of money that has gone into public education around the war on drugs over the last 70 years, that's a pittance. And at least some of, and I think this, at least some of the problems that we face as a country to do with understanding and believing and having faith in public health information coming from the government can be tracked to what our own government has said erroneously to us about many things, including the risks of substances like marijuana to us. And there is an enormous history around this that goes back to the pre-New Deal era and prohibition. But in any case, if you counterbalance the amount of misinformation the government has, over many, many decades disseminated with the pittance of $6 million of re-education coming from New York to Oregon, I'm not that persuaded that that's such a bad thing.
I also just wanted to add, if you even look at the original Controlled Substances Act, marijuana is a Schedule I drug, while sort of those opioids are Schedule II, just because marijuana has always had this sort of propaganda effort, for lack of a better term, against it back to the 1930s. So I think it's sort of always been a problem, and I'm sure the opioid crisis definitely didn't help, but it definitely is not sort of born out of that.
One of the things I'd also say, which, you know, I think is really, it is at least an important theme in our paper, and I think it's important to say, is that conscious altering activities are not per se bad, the way that governments describe them. So, and on the therapeutic side, writers like Michael Pollan have written books like How to Change Your Mind that have talked about the very positive effects of psychedelics on terminal illness depression and on response to PTSD for veterans. Even more fundamentally, writers like Michael Pollan have written about how there are at least some sort of non-frivolous arguments that religion and the source of religion can be tracked to the access that people had many, many hundreds of years ago, if not, you know, many, many hundreds, if not thousands of years ago, to mind-altering drugs. And there's also a very, very potent tradition of artists of the highest quality, most groundbreaking, relying on drugs and psychedelics in order to access different ways of thinking about the world. And so when you think about drugs from that, you know, I guess we call them drugs from that standpoint, there's something really even Orwellian about the mind control policies that underlie the Controlled Substances Act. I say this is a square. I mean, like, you know, you're talking to a person who graduated from law school, clerked for a former prosecutor, was a prosecutor for 6 years, and was not a drug user. But the more that I study the problem, the more concerned I am by it. And, you know, and so anyway, that's what I'll deliver to you about it.
Last questions?
Anyway,
thank you guys.
thanks for having us.
Absolutely.
Good job.
So just, I'd like to give just one more quick round of applause for all of our awesome